So you win, boss.
How'd your daughter make out in the draft?
She said she had a good time.
Good.
Test.
They had a
Good morning and welcome to the Maryland Public Service Commission. I'm your friendly chairman, Kumar Barve, and the commission will come to order, and we're on record in case number 9820. This is a trial type evidentiary hearing publicly noted in the procedural order that was issued back on December 8th, 2025. In that order, the Commission set forth a procedural schedule to accommodate a filing that Pepco made on October 14th, 2025 to set base rates for electric distribution service beginning August 10th, 2026. Pepco initially filed an application for authority to adjust its retail rates for distribution of electric energy and implement a fully forecasted test year. However, on April 14th of this year, Pepco filed a notice with the Commission stating that it is not pursuing a fully forecasted test year in this proceeding based on legislative developments under the Utility Relief Act, which, once signed into law by the governor, suspends consideration by the Public Service Commission of forecasted test years in a base rate proceeding pending a commission study within the allowed time frame. So we'll begin today by taking appearances of the parties in the general order in which the parties will make their case. So we will begin, we'll do it in this order. It's going to be first, of course, Pepco, then AOPA, then MEA, then OPC, and finally our staff. So if you'd like to make a presentment.
Good afternoon, Chairman, Commissioners. Kim Curry, representing Pepco. I'd also like to enter the appearance of Ann Bancroft, Matt Seegers, Doug Michael, and Taylor Beckham.
Okay. Next, AOPA.
Good morning, Commissioners. I'm Fran G. Francis, appearing on behalf of the Apartment and Office Building Association.
Okay, thank you. MEA.
Good morning, Michelle Honig on behalf of the Maryland Energy Administration. I'm also entering appearance of Bhavita Modi, Nina Wu, Jeffrey Genzer, and Thomas Rudabush.
Thank you. People's Council.
Good morning, Chair. Michael Sammartino for the Office of People's Counsel. I'd also like to enter the appearance of Jacob Auslander, Ryan Shu, and Pauline Raisis.
Thank you. And finally, our...
Montgomery County, Diane Kilcoyne, Kilcoyne, entering an appearance. Thank you.
Thank you, Diane. Staff.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. I'd also like to enter the appearance of Ruthie Herman, Harrison Scher, and Shauna Wilkerson.
Okay, thank you very much. Before we proceed, I'd just like to, as a relative newbie to this, I'd like to go through the rules and just give you an idea of what the time schedule for all of this is going to be. It's important that, first of all, obviously, it's important that you speak clearly for the court reporter, and if you have not given the court reporter your name in advance, you would, of course, have to spell your name so that he can make sure to note it correctly. If you're not actively speaking, your microphone should be muted. I'll call for a 15-minute recess sometime in the morning and a 15-minute recess in the afternoon. We will take, I think we're going to try and do an hour for lunch so that people can actually get out in a civilized fashion and eat something, because this is a long hearing. I am going to try to adjourn between 4:30 and 5 p.m. I want to get as much work done as we can. We've scheduled 5 days, and I'd really like to have it only be 5 days, if that's at all possible. Let me state at the outset of this trial that this is a particularly complex case. We have before us a relatively large rate application that is several thousand pages long. We have hundreds of pages of testimony, dozens of exhibits that were filed on rebuttal and sur-rebuttal. We have before us today several parties sponsoring witnesses, hence we have a need for some ground rules to take to make the trial more efficient. So let me read those off to you right now. Number one, regarding examination, witnesses will be limited to examination on direct, cross, and redirect. Number two, cross-examination is limited to the scope of the direct examination of the witness, and redirect is limited to matters brought on during cross-examination. Participants on the same side of an issue, of course, may not cross-examine each other's witnesses on that issue. Cross-examiners will not be permitted to be repetitive subsequent to cross-examination. Number three, an objection to a question put to a witness during cross-examination may only be made by counsel sponsoring that witness, and a request for clarification of the question on cross-examination may only be made by them. Four, cross-examination is not a substitute for discovery. Questions during cross-examination designed to educate a party of the substance of another party's pre-filed testimony or otherwise obtain information that could have been easily obtained during discovery will not be allowed. Five, all witnesses will be subject to recall by the bench with appropriate notice. Six, witnesses will be dismissed at the conclusion of this hearing. We're aware that there are some witness availability issues, and we will do our best to accommodate those constraints. That's with respect to examination. Number seven, with respect to exhibits, every exhibit offered into evidence must be properly authenticated and have a foundation laid prior to admission of evidence. However, I will have the option to waive the authentication requirement if parties stipulate to the exhibit's authenticity. Eight, finally, when an exhibit is referenced during the hearing, the examining attorney should make a specific reference if it is a pre-filed exhibit. Nine, as I stated earlier, this is a very large case that we're dealing with, and the commissioners will need a moment to either go to their paper copies or find their electronic copies for those exhibits. With that, with all of this, are there any questions that council have? And I don't hear any, so we will, with none of that, the utility will proceed to. Oh, let me proceed first to preliminary matters. Does the utility or any of the other interveners have any any preliminary matters you want to discuss or present?
Pepco does have preliminary matters. We have 4 of them. Should I go ahead? and
Sure,
jump
go
in?
ahead. Yeah.
All right, the first preliminary matter is the company will be using the clean versions of the testimony that we filed on April 24th pursuant to your April 22nd letter order directing us to file clean and red line copies. We will be using the clean versions of the testimony that we filed on April 24th, pursuant to your letter order to file clean and red line copies reflecting the FFTY portions that we are removing. With the exception, with 2 exceptions, we did notice that 2 of the testimonies were missing some information, and we filed those this morning. Those 2 exceptions to the clean that we will be using are part 1 of the rebuttal of the Lemming testimony. Company witness Lemming's testimony was missing 2 schedules. We refiled that this morning. Those 2 schedules were part of the original rebuttal testimony, so it's not new information. It was just, due to an inadvertent oversight, was left out of the filing on April 24th. The other thing that we filed this morning was part 2 of the direct confidential version of company witness Lemming's testimony. Did not contain all the changes that we had identified in the April 17th letter to remove. We refiled that this morning, and we have copies in the room here to distribute to the parties when Mr. Lemming takes the stand. That's the first preliminary matter I had. The second preliminary matter is the company removed the testimony of company witness Tiladar. His testimony was focused on the fully forecasted test year, FFTY, so we have removed that testimony. The third item is to enter the certificates of publication into evidence. These are the certificates of publication announcing the evening public hearings, and I'll do that in a moment. And then the fourth item is there are some open motions. We have a motion for confidentiality that we filed. AOBA filed a response to that. And we also have a motion to strike the testimony of AOBA witness Oliver. And so those would be two items that we would like a ruling on, those two motions. And I can argue those when you are ready.
Okay, very good. Well, let's go through the list. AOPA, you're next.
Okay, obviously I want to respond to the two motions, the motion for confidentiality and the motion to strike. Since I'm first up, probably crossing witness Lemming, I haven't seen the new filing that they made with the new testimony and what's in, what's out, so I'll try to work my way through that. The other concern that I have, much of the testimony has to do with what what Pepco has chosen to strike. Not so much that I'm objecting to any one part of it, but I have concerns about all of it. In other words, the company is no longer requesting a fully forecasted test year. Much of AOBA's testimony and some other testimony has information about the fully forecasted test year interwoven with their testimony regarding the traditional test year. And I also want to point out that the company is not striking witness Williams, and I'm not asking them to strike witness Williams, but the majority of his testimony has to do with the fully forecasted test year and new business investments. And obviously, the company wants to recover some of these new business investments under the traditional test year, not necessarily the fully forecasted test year. But his testimony, his direct testimony I'm focused on, is replete with mentions of the fully forecasted test year. So my concern is, I recognize Pepco is not requesting recovery of a fully forecasted test year revenue requirement, but since so many of our expert witnesses, and I could go through a couple of other examples, discuss the fully forecasted test year, some of their information in regard to coming up with a test year revenue requirement, I ask that it be let in where it's interwoven with other companies, with other witnesses, and that the company just not rely on it in their request for a fully forecasted test year, since they're not asking for that. So that's the next thing that I have, and I think I'll hold whatever else I have perhaps for a later time. I think that's enough, and I would like to respond to Pepco's two motions at the appropriate time.
Okay. Next, MEA, if they have anything. All right, thank you very much. Then we'll go to OPC.
Thank you, Your Honor. So I guess just responding to Pepco's removal of Mr. Tulidar's testimony, OPC witness Ben Havamaki, he responded to Tulidar's direct and responded to Tulidar's Sur-rebuttal. So we, consistent with Pepco's removal of Tulidar's testimony, OPC witness Havamaki's testimony will also be removed. It doesn't have any bearing on the traditional test year compliance filing Pepco filed. I'll also say that to an extent, we share similar concerns with AOBA about the completeness of the record. It's hard for OPC to identify the portions of its testimony that relied only on the portions that Pepco counsel has determined to be specific to the traditional test year compliance filing. So we await a ruling on whether our preference would be for the full, all of the testimony that Pepco filed to go into the record, just to ensure that we're avoiding a situation where there's a reference in a witness testimony that refers to portions of direct testimony that's been not entered into the record. So just for a completeness of the record perspective.
So let me be clear that I understand your position. You want to enter what again? The whole, everything, including the fully forecasted test year?
We think that that could avoid some potential unintended consequences with the late the last minute kind of striking of Pepco's fully forecasted future test year. So the clean version that Pepco just filed on Friday, that would be the testimony that Pepco is relying on. But there are portions, as Ms. Francis noted, there are portions of the testimony that our witnesses respond to, that other witnesses respond to, where it kind of interweaves issues that are consistent with both the fully forecasted test year and the traditional test year. So we prefer to have, just for ensuring that the record is fully complete, that all the testimony that's been filed be entered.
If that, oh, okay, fine. Then let's proceed to staff.
Thank you, Your Honor. Staff has a few items. First of all, we filed a order of witnesses with some of the restrictions that we were aware of. Staff would like to state that we found out we have an additional restriction. Staff witness Lowe cannot testify on Thursday due to double scheduling in another hearing. So he'll have to testify either on Wednesday or Friday. Secondly, Pepco didn't bring this up, but I believe there's a petition regarding removal of street lighting testimony. I don't believe the commission has stated its acceptance of that filing.
That is correct. We do, the company did withdraw the testimony of Matt Bowen. That was our streetlights witness, and 4 questions in the testimony of Lance Schaefer. We view it as being able to remove testimony if the company finds it appropriate. We didn't necessarily think that commission approval was needed for that. We had presented the testimony. We decided that we did not want to, well, pursuant to an agreement with the municipalities, that we did not need to pursue the subject matter of Mr. Bowen's testimony in this case. We're going to pursue that in case number 9703, the streetlights case. So it was really a joint agreement between the company and the municipalities, and the municipalities were the ones who responded to Mr. Bowen's testimony. So the 2 parties that had the interest in this have agreed to voluntarily remove it. So we were not seeking a commission approval. It was just a notification to the commission that we had come to this agreement and we're removing the testimony.
Okay, first on that issue, yeah, I mean, I think that's fine. I think we agree with you on that point. Second, the confidential, recap again the request for confidentiality. This is the motion that we have with AOBA. Yes. So that was a situation where there was a a data request that asked for information on our rate case costs. We provided an exhibit, or we provided a response that contained the invoices of our consultants. We inadvertently provided that publicly to the parties. We served it on the parties publicly, and it contained the charges, the specific charges that our consultants charge. We realized that unfortunately, after AOBA witness, Mr. Bruce Oliver, filed his testimony, we didn't want that information public. The reason why is because that could harm our consultants in the marketplace if they're negotiating, their rates with a subsequent clients, if it's public and available. And we have provided similar information
under confidential cover in 2 recent rate cases. So it was completely an oversight on the company's part. And so what we did is asked AOBA if they could refile their testimony with that exhibit as confidential, because right now it's public on the commission's website. There was also some banking information that was exposed. We talked to AOBA, and AOBA, which we appreciate, filed a redacted version that removed the banking information but left the consultant charges public. So what we were looking to do is to have AOBA make that attachment to Mr. Oliver's testimony confidential. And we do have copies of that. So if any party wants to use that exhibit with any of our witnesses, we do have confidential copies that we can distribute to the participants in the room.
In response, Your Honor, the company, as they said, they filed this as a public document back in December in their response to staff data request 13-15. So it was out there for all the parties to see then. Then, on March 11th, in witness Lemming's testimony, there's a footnote on page 20, footnote 4. I'm going to read it. Pepco's response to staff data request 13-15 includes an attachment that contains actual invoices billed to the company related to case number 9820 rate case expenses through November 30th, 2025. This approach is consistent with Pepco's provision of rate case expense invoices in discovery in case number 9443. Refer to case 9443 rebuttal testimony of company witness Zeminski, and it cites the pages. So on March 11th, the company invited people through witness Lemming's direct testimony to access the data response of 13-15. AOBA agreed that banking information is totally irrelevant to this case. We had no interest in it, and it was a clear oversight by Pepco, so we agreed to redact that information. However, we do believe that what they're paying their consultants has to do with obviously rate case expenses, and it should be open information for others to see. And as of March 11th, Pepco did not refer to it as a confidential document. It was a public document, and they said what it was and for the parties to look at it. Now, anybody who's seen that information, they can't unseen it. So it's been out there. At the very least, it's been out there since March 11th. It didn't come to Pepco's attention until AOBA filed a copy of it in its testimony filed on the 16th. So I ask that it be left in because that should not be confidential information.
The DR was at staff's request. Does staff have a comment on this issue?
Staff did not take a position on the issue.
Well, do you have a position? I mean, you didn't prior, but do you have a... Thank you, Ms. Herman.
Good morning, Chair and Commissioners. Ruthie Herman on behalf of staff, and that's H-E-R-M as in Mary, A-N as in Nancy. Whether a document is subject to disclosure or not before a public entity is subject to the general provisions article of the Maryland Annotated Code and extensive case law in Maryland's appellate courts. An entire document should not be blanketed confidential, but rather a party should redact it and file the redacted version as in the public docket, and then the confidential version in its entirety in the proprietary docket. Before the confidential part, begin confidential, end confidential. And those words should be in the public document, and then the redacted parts. And then in the confidential document, those words should be there too to signify that section. But Maryland law does not say that an entire document should be blanketed confidential. And this has come up. This came up in 9702, and we were able to work it out with Pepco after quite a bit of back and forth. But thank you.
Okay, thank you for clarifying. Do you have a?
Yeah, so, Ms. Herman, I guess it doesn't answer the question about sort of, post hoc, sort of identification of confidential information that the utility believes it should redact. I mean, they're not asking to redact the entire document. They're just asking to redact the amount that they pay to their consultants. Is that correct?
No, we are okay with leaving the charges seen and visible. We just want that page to be confidential.
You want the whole page?
Yes, the whole
Okay.
page.
So is there an alternative? Can you, if you were to redact the rates that are paid, since that seems to be the issue in play, is that, but you would want the rates because you're trying to make the case that they're overpaying their consultants.
And they're overpaying their consultants that are now outside consultants that used to be working for the company. So that is part of what we are arguing, and we think the rate should come in as well as the total charges.
Yeah, I guess Mr. Chairman, I'm sort of troubled that it's already out there and everybody has seen it, and I think it's very hard to unscramble an egg at that point. And it just seems to me that if some of AOBA's case is to be able to demonstrate, I mean, if you paid your consultants $1 million an hour, that would be information that we would want to know, because that would represent that you're overpaying, or at least someone can make that case. They can't make the case if they can't provide the information.
We agree that that information should be available to the parties who have signed an NDA and to the commission. We're not proposing to redact that. We are just proposing to make the invoice confidential. So what would happen is it would be filed on the confidential side of the docket. We could use it here in the room in confidential session. It would just not be available on the public side of the commission's website. But we agree the charges should be viewable. We just want those charges to be confidential.
But how do you deal with all the other people that are out there that have already seen it and have printed it and have access to it? What do you do about that?
So there's nothing that can be done about that per se, but what we're trying to do here is stop the bleeding, right? So it's possible that people aren't necessarily perusing the commission's website and have seen this document, but the longer it's out there, the risk grows. So this is to mitigate the risk. Understand that it has been out there since March 11th, but the longer it's out there, the more chances people can see it. So it's all about stopping the bleeding today. Understanding people can't unsee it, but we'd like to kind of stop it from this point on, people having access to that information on the public part of the commission's website.
I think Commissioner Linton had a question.
Yeah, good morning. Just thank you, Mr. Chairman. Just quickly, has the company already filed a confidential version of this document?
It is a data request, so we did not file it. We served it on the parties, and we inadvertently served that on the parties publicly. But it was just the parties within a SharePoint, not broad distribution. It was just exchanging our data response with the parties.
So you didn't make it public?
We did not make it public. We served it on the parties. It's public as it relates to the parties, but again, it's just an email. It's just a SharePoint site that only the parties have access to. So we have served it on the parties, and that was not a confidential document.
So you didn't mark it as confidential when you served it on the parties?
Yes, correct. And it was, again, an oversight. It was something we just didn't recognize until we saw Mr. Oliver's testimony.
Okay, all right, thank you.
So, I mean, it's the barn. The horse has clearly left the barn. To pile another cliche on top of this, but I mean, I think that since the commission has access to all this information, I think the commission is fine with granting.
Your Honor, the commission may have access to it, but the public does not. And the theme throughout Pepco's case is all a matter of transparency. And the question is, how transparent do we want to be with the public? Do we want the public to know, which I think they should, what do these rate cases cost? What is Pepco paying its outside consultants to put on a rate case for whether it's $142 million or $119 million? What does that cost? Do we want the public to know it? That theme of transparency is discussed by many Pepco witnesses, and they're saying that's what they're trying to do. So if that's what Pepco wants to do, I think the public should be aware of it. It was interesting that Mr. Carr filed comments in the docket last night, and he made reference to the fact that the public cannot get access to data responses. That is a concern if we want the public to be aware of what's happening and what these cases cost. So I think what's in this document should be out there for the public to see.
And what we are,
Ms. Francis, would you be making this argument but for the omission or the error by Pepco to disclose this inadvertently? Would you be jumping up and down saying this should be public?
I probably would have requested it that it be public because I've asked for this data before. I didn't have to because staff asked for it. So I don't think I'm really jumping up and down. I'm just
I understand
kind of
that, but-
responding to a motion that was filed.
Right, but I'm just wondering, would you be making a motion to make this information public?
I might
Had it
be.
been, but for the error?
I might be. I can't, it's hard for me to answer. I can't answer that, but I think that I would think that this should be public.
and what we're looking for is the charges. We want the charges to be confidential. This is the hourly rates. What I'm referring to is the consultants' hourly rates. That's what we're looking for, it to be confidential.
Go ahead.
So it just seems to me that I'm a little concerned about competitors getting access to information that they shouldn't have, and so I'm sort of sensitive to that. I don't think it impedes your ability to make the overall case that Pepco is overpaying their consultants, and it certainly doesn't impede your ability to make the case that Pepco is just paying too much outside without the specific numbers, because we'll have those numbers, you'll have those numbers, OPC will have those numbers. So I think that you can, I guess, is there anything else in that invoice that needs to be redacted?
Well, most of the invoice are the charges per hourly rates and the total charges. So that is, for example, I'm not going to repeat the numbers now, but whatever Pepco is paying for its outside consultants, is that reasonable? Is that what other consultants are paying? And is it more or less than Pepco was paying in previous cases for these very same witnesses who at the time were in-house witnesses? And clearly Pepco does not have the in-house expertise.
And you'll be making this case, and you'll be asking questions about that.
Will I be asking questions about it? No, but Mr. Oliver has addressed that. No, we were not going to focus on the numbers in a live hearing. I try to stay away from that kind of information. No,
So you're not going to be asking questions about the numbers?
no, I am not.
Well, that actually sort of suggests that this is sort of a balancing. We have to protect consultants that are making a living, that are competing against others. At the same time, we need transparency. But if you're not going to be asking questions about the numbers, it just seems to me that sort of militates, Mr. Chair, in favor of granting Pepco's motion.
Yeah, the sense I get from the commission is that we're inclined to grant the motion, so that is what we will do. We're not going to take a formal vote, but no. Okay, granted. Next issue is.
Your Honor, does that, okay, can I just be clear? How do you want AOBA to refile its testimony? Because I've already had one set of testimony taken down, and I've worked with the executive secretary's office to accomplish that. Now you want me to take that down and refile it as a public version of Mr. Oliver's testimony, and then one as a confidential version of Mr. Oliver's testimony.
Yeah,
Okay,
I believe so, yes.
okay. That'll take me a day or so to get done since I'm here.
Yeah, well,
Okay.
we're accommodating to issues having to do with logistics. Any other issues? Did we cover everything?
The second motion that Pepco has is the motion to strike the supplemental sur-rebuttal testimony of AOBA witness Bruce Oliver. Here, this is, the argument that we made is, twofold. One, supplemental sur-rebuttal is not permitted by the existing procedural schedule. And two, what AOBA is reacting to is sur-rebuttal that was filed by the company. The company filing sur-rebuttal in a traditional case on the same topic is something we have done for 12 years, and going back at least 4 rate cases. In AOBA's motion opposing in AOBA's response opposing our motion to strike, they made a few arguments. They said Mr. Nelson's testimony, company witness Nelson's testimony, what it does is that it updates some RMAs. This is rate-making adjustments. This is sur-rebuttal. We've done sur-rebuttal of this type, as I mentioned, for the past 4 rate cases going back 12 years, so we feel like it's appropriate. It's consistent with prior practice. AOBA also makes a couple of arguments challenging the length beyond the test year that the RMAs extend. To that, I respond, this is not appropriate for a response to a motion to strike. It's not appropriate for oral argument for attorneys. If they have a problem with the length of the post-year period of the RMAs, that's something that AOBA can handle in discovery, in testimony, in briefs, in cross-examination, because what it gets to is an RMA has to be known and measurable. So if we can prove that these RMAs, no matter the length that it goes out beyond the test year, is known and measurable, we should be able to make that argument, and AOBA has every opportunity to challenge that. So Mr. Nelson's testimony should remain in the case. If AOBA has challenges to that testimony, she can cross-examine Mr. Nelson on that point.
Yes, thank you.
Brian?
What Pepco filed was...
speak
Oh, I'm sorry.
Thank you.
Okay. What Pepco filed was not sur-rebuttal testimony. They filed actually supplemental direct testimony in regard to RMA 2. And what they filed in regard to RMAs 3 and 4 was actually an errata. They were making corrections. So there was, in the commission's order in this case, it was not on the schedule or the procedural schedule adopted for Pepco to be filing sur-rebuttal testimony. There is nothing in witness Nelson's April 16th so-called sur-rebuttal testimony that directly responds to a position offered by any other party. It's more like supplemental direct testimony. And I'm also going to ask the commission to recognize the timing and the magnitude of the changes that Pepco witness Nelson has put forward in his sur-rebuttal testimony. And what that does is it undermines AOBA's ability to meaningfully respond to those changes within the existing rebuttal schedule. The corrected work papers were not provided until April 8th, and the updated RMAs were not filed until April 13th, 3 days before the April 16th filing of sur-rebuttal testimony. The commission's schedule did not anticipate that any party would introduce materially significant new figures 3 days before the scheduled due date for sur-rebuttal testimony. Pepco treats every time it makes an announcement that it's going to file an update or corrections, that it's just a license to deviate from the schedule. We disagree with the way Pepco has been handling that. When the Commission adopted its original schedule in this case, it was designed to ensure the orderly and fair exchange of evidence between the parties. It shouldn't be a last-minute attempt for Pepco to abrogate the schedule with just another ad hoc filing, which is not actually sur-rebuttal testimony. So we ask that in due fairness, the company did not come and say, we want to put on supplemental testimony. We understand that the parties may need to do discovery on this additional supplemental testimony. So Pepco is willing to extend the due date for parties to do a bit of discovery and then meaningfully respond. We did not get that from Pepco. We're all under the same time frame. And I think that in order of fairness to properly address Pepco's additional supplemental testimony, that Mr. Oliver be allowed to submit his supplemental sur-rebuttal. And I also want to point out that staff recently has also submitted supplemental testimony in the record in regard to one of its witnesses.
Any questions? Go ahead, Bonnie.
So if we were to accept your supplemental sur-rebuttal, then that would address your concerns about what you believe is new information coming from Pepco.
Correct.
Okay. And Ms. Curry, can you respond to AOBA's concerns about introducing new information in your sur-rebuttal testimony?
Yes, I can. I can respond by using an example. In our last traditional case number 9602, we did this exact same thing. We filed information 3 days before we filed our sur-rebuttal. We filed it 3 days just so parties would have more time to review the information. So it's basically work papers that we filed 3 days before sur-rebuttal, and then in sur-rebuttal, we provided the updates to the RMAs. We did this exact same thing in case number 9602. AOBA was a party to that case and did not raise this objection there. I think one of the issues that AOBA may be misunderstanding is we've had MIPs for the past 5-6 years past 5 years for Pepco. This is a practice that we employed with traditional cases to update the RMAs in sur-rebuttal testimony. Again, something we've done historically for historical test year cases. So it might appear new to AOBA, but it is very consistent with a well-established practice that we've done before. Allowing the testimony in, even if we're allowed to do rejoinder on it, still doesn't kind of get us where we need to be. The reason why we want to strike it all together and not even employ rejoinder is it really does impair our due process. We have to have the last word as the moving party, and to get this testimony 3 days before the hearing, it makes it hard for us to prepare for that. So AOBA is trying to introduce a new process that has never been done in a traditional case before. This has been a process that they have lived with for, many traditional cases.
May I respond, Your Honor? Okay.
Please.
I think Pepco is getting mixed up with what has become a company practice with what is actually commission precedent. There is no information right now available. What was the magnitude of the adjustments that were made before? The magnitude of these adjustments are noticeable and substantial. And being that counsel for Pepco has talked about prior cases, I'm going to quote from order number 88432 in case number 9443, where the commission has said The discovery problems in this proceeding have demonstrated that parties need time to respond to updated actuals in order to properly scrutinize the data and make a recommendation of the appropriate treatment of rate-making adjustments. And the commission goes on from there. So there is precedent not to allow Pepco to be able to do something without giving the parties the appropriate time to respond. So that's what AOBA is asking for. We do believe they have several days. Mr. Olivers isn't going to be taking the stand for several days now to properly prepare a rejoinder to his 3 or 4 pages of supplemental sur-rebuttal.
Well, okay. I actually think AOPA makes a fairly decent argument here. So my read of the commission is that we're going to deny that company motion. What else do we have before us before we go to testimony?
I'd like to, for the testimony, I was going to enter the certificates of publication into the record, but we can address your testimony issue if that's better now, and then we can enter in the certificates of publication once we kind of get into the meat of the hearing.
Why don't we do it that way, if that's okay?
Yes.
Okay.
Did you have a question about testimony? When you said get into the testimony, I didn't know if you wanted to.
No, I just wanted to make sure that all the preliminary matters were exhausted before we got to staff.
We had a third item as a preliminary matter. The testimony of staff witness Fidei and Hoppick, since they involve fully forecasted test year testimony, we are not going to enter that into the record. Staff would also note that when we filed our supplemental sur-rebuttal testimony, it was only to remove the fully forecasted test year information from that testimony. We didn't add anything.
All right, so I think that's fine. Grant that. Any other preliminary matters before Pepco calls its first witness?
Your Honor, is there any clarity that we'll get on which testimonies Pepco will be offering into evidence? I think in the preliminary matter I raised, I asked if we could get clarity on whether Pepco will offer all of the testimonies it's filed, included the TTYCF only versions, or whether just the TTYCF testimonies will be admitted into the record.
I mean, I think. Well, go ahead.
So this is an unusual situation, and in asking for Pepco to provide red line and clean versions, it was mostly for administrative efficiency. The challenge is there's still fully forecasted references even in the clean version. I think it would have been an impossible task to have everybody go through all of the testimony and strike all of it. So it just seems to me that the most obvious of testimony, where it's solely fully forecasted, it makes sense to not include that into the record. But it seems to me, I mean, Mr. Lemming's testimony, there's still references to fully forecasted. I don't think anybody's sort of challenging whether his testimony should be allowed or not. So it just seems to me that if it's obvious that the testimony should not be introduced, that should be struck. But otherwise, I think it would be a fool's errand to try to go through every single line and try to strike it. So I think the rest of the testimony has to be admitted when it's being offered.
Right, I agree, and but it is unusual because of the legislation and the recent decision by the company to present their case in this way. I think that we all feel that everything, to the extent that we can, we should include as much information. But obviously, the company is not. They're pursuing a historic test year case, so that's the position that we will go with. But if information can be included, I think it ought to be. So,
Your Honor, Our position was to file or to use the testimony that we filed on Friday with the two exceptions that I mentioned. We have copies here in the room. And I wanted to see if that is consistent with your ruling or if you were requesting that the company do something different. The reason why I mention that is the copies that we have that, that our witnesses have are the ones that we filed on April 24th.
Yeah, I think the answer is yes, it would be consistent.
All right, thank you.
Your Honor, there's one other matter I neglected to mention. OPC witness Madsen is currently he's a Canadian citizen. He has visa difficulties and currently can't enter the United States. That was not the phone call I wanted.
Really scary these days.
I know.
That was not the phone call I expected from my witness last week. We reached out to Secretary Johnston to let him know that we were requesting virtual accommodations, and I just wanted to
Yep.
remind that matter here. And
It's a shame we have to do this, but yes, that's completely logical.
thank you, Your Honor. And I remain optimistic that Dustin will be able to be here in person to meet you all.
We don't want to get him in trouble with ICE.
Thank you.
I shouldn't have said that. We have no idea why. Shouldn't have said that. Okay, so I think we're prepared to have Pepco call their first witness.
Before I do that,
What? Oh.
I'd like to enter into evidence as Pepco Exhibit Number 2, the certificates of publication for the evening public hearings. We filed that on April 16th under Mail Log 329063.
Without objection, so marked and entered.
The company calls Mr. Lemming to the stand.
What is this? Well, you know what? Let me put it some. You hold on to it because I'm not going to be able to work it into my. Just hold it for a little bit. I'll get it. Okay. Well, all right. Give me. Is this all for me?
Yes, please. That's all.
Yes, I do.
Mr. Chairman, I had mentioned earlier
Let's
that.
make sure that the court reporter has the name and spelling. You've got it, okay. All right.
I had mentioned earlier that we had inadvertently left off two exhibits to Mr. Lemming's rebuttal testimony. We have copies if the commission would like some. Please
Sure.
let us know.
Yes.
All right, we'll get you some copies.
What are they? What are the two exhibits you left off?
The two exhibits are RTL-R-1 and RTL-2. RTL-R-2.
Okay.
Mr. Lemming, please state your name and title for the record.
Good morning. My name is Robert Lemming. I'm the Vice President of Regulatory Policy and Strategy for Pepco Holdings.
And do you have before you a document entitled Direct Testimony of Robert T. Lemming, Part 1?
Yes, I do.
Does that document consist of 32 pages?
Yes, it does.
Was that testimony prepared by you or under your supervision and direction?
It was.
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same questions today under oath, would your answers be the same?
Yes, they would.
Your Honor, I would like to have the direct testimony of Robert T. Lemming, Part 1, marked for identification as Pepco Exhibit Number 3, and move that it be admitted into evidence.
Without objection, so noted and entered. Wow.
Mr. Lemming, do you
Look at all
have
this
before you a document entitled Rebuttal Testimony of Robert T. Lemming, Part 1?
Yes, I do.
Does that document consist of 32 pages and 2 schedules?
Yes, it does.
Was that testimony prepared by you or under your supervision and direction?
Yes, it was.
Do you have any corrections or deletions to make to your testimony at this time?
No, I do not.
And if I asked you the same questions today under oath, would your answers be the same?
Yes, they would.
Your Honors, I would like to have the rebuttal testimony of Robert T. Lemming, Part 1, marked for identification as Pepco Exhibit Number 4, and move that it be admitted into evidence.
That objection so noted and entered.
All right, Your Honors, I would like to ask the witness questions on live rejoinder.
Proceed.
Mr. Lemming, have you reviewed the sur-rebuttal testimonies of MEA witnesses Lombardi and Balakumar?
Yes, I have.
And before we delve into the details of those witnesses' proposals, do their testimonies discuss any specific recommendations that you would like to respond to?
Yes, certainly. So, in MEA's sur-rebuttal testimony, in their review of the White Flint substation and an analysis their witnesses performed, they actually have a discussion about a number of forward-looking policy dockets as well as measures that they think would be conducive to helping advance state policy. Specifically, I believe it's on page 58 of MEA witness Balakumar's sur-rebuttal testimony. He talks about two forums, including the energy storage, or sorry, not the energy system planning docket, as well as multi-year plans, as two mechanisms that help advance, his characterization of transparency, alternatives analysis, and overall process and engagement from stakeholders into utility planning that would help provide a constructive forward-looking vehicle for advancing state policy. I would just like to note that Pepco wholeheartedly agrees with those recommendations and recognitions from MEA witness Balakumar. I know lessons learned around MYPs is something that continues to progress, and we're looking forward to constructively working in that docket to get that into resolution. And if we are able to have a constructive framework to file under, would enjoy being able to file in that manner in the future to provide transparency to parties around how we're making our planning decisions and evaluating alternatives.
All right, on page 4, lines 7 through 11, MEA witness Lombardi recommends that a series of approval criteria should be implemented before Pepco's next rate case or within a year of the Commission's order in this proceeding. How do you respond to that recommendation?
I think that the company is generally supportive of the notion of collaborating and working through existing dockets and processes that the Commission has in place around electric system planning, as I noted. I do not think it's necessary to put necessarily a time clock on the company in terms of when specific filings will be made, but I do agree and recognize that I think we're going to have a number of opportunities coming up over the next year, including this June, for instance. We're going to make our first filing under the DSP process. And I think that presents an opportunity where we would enjoy being able to work with MEA as well as any stakeholder across the state, for that matter, on what a potential NWA evaluation framework might look like, so that we can work towards advancing that and then ultimately include that in our full filing I think we need to make in 2028, as well as, like I mentioned, any future rate proceeding if we're able to do something like an MYP.
At page 7, lines 20 through page 9, line 3, MEA witness Balakumar discusses the company's White Flint investments and criticizes the company for not performing an NWA analysis. How do you respond?
I would respectfully disagree with the notion that the company did not perform an NWA analysis. I'll defer to company witness Allo. Will be up here later during the proceeding to talk about the technicalities of how the company went through their processes. But I will say we did conduct an alternatives analysis. Non-wireless alternatives were considered in that analysis, and we have included information in the record to that effect. I think we're looking at a situation where a lot has transpired since 2016. We're now, like I said, working towards a distribution system planning docket where we are putting much more robust frameworks in place in terms of how we go about these comparisons and make these evaluations. And just want to caution against exercising or leveraging any of the learnings and new things that we may have put in place in terms of frameworks today, in terms of evaluating a decision that the company made 10 years ago, back in 2016, to pursue a project as a form of retroactive hindsight prudency review, if you will. So just want to caution against our view of the appropriateness of doing so.
Witness Balakumar discusses a desire for the company to investigate and deploy a DER roadmap and dynamic flexible interconnection program on pages 71 and 72 of his testimony. What is your reaction to this?
Again, I'd like to just first recognize and say that we appreciate MEA and specifically Witness Balakumar. I think commented on the steps we have taken forward in this space since we filed our direct testimony back in October, and recognizing we have made significant advancements in terms of our DER roadmap that was demonstrated through our Drive Act filings late last year into early this year, as well as discussions and proposals we've had as well as in our FERC 2222 docket. And so, I think a tremendous amount has been advanced in that space, and the company looks forward to opportunities to continue to work with MEA over the next year to continue to advance those. We have things coming up like our phase 2 of our storage procurement process. The commission has recently opened up PC 77, so I think the appropriate forums do exist over the next year where we can have those engagements and work with stakeholders on that type of information.
On page 76, lines 10 through 15 of his sur-rebuttal testimony, Witness Balakumar recommends the company develop an integrated data platform to support the deployment of DERs and support customer affordability. What is your reaction to this?
Again, and I think MEA has had a recognition of this. We have been taking steps towards doing that. We are currently implementing a utility-scale DERMS. But in the meantime, we have advanced data sharing platforms, again, within the context of our drive filing. We've talked in FERC 2222 about the importance of having a cost-effective, perhaps statewide, data sharing platform in place. And so we continue to be interested in moving that type of technology forward and think, again, we have opportunities to do so here over the coming year. I think an important point of consideration is just, we need to do so, I think, in alignment with commission process, whether that might be an MYP or within those dockets I noted where we can talk about the timing for these deployments, the impacts to customers, as well as the utility, and so we can balance all of those stakeholder interests as we're rolling those things out for the benefit of our customers.
So while the company is aligned with the intent of forward-looking initiatives, does the company agree it's appropriate to use those forward-looking initiatives as measures for prudency for investments the company is seeking to recover in a rate case?
No, I do not, and that's where I think we diverge a bit from MEA in terms of the proposals in this proceeding. In their sur-rebuttal testimony, again, and appreciate the recognition and the discussion around the importance of these policy initiatives that we're working towards. MEA has conditioned that if we don't do certain things within a time bound, that recovery should stop on past investments that we've made that are currently used and useful for the benefit of customers. I would say that the company strongly disagrees with that recommendation and find that to be counter to longstanding commission regulation and law. I'm not a lawyer, but so I will caveat that. But my understanding through my experience in regulation has been the company and utilities in the state are entitled a reasonable opportunity to recover their prudently incurred costs as well as earn a fair and reasonable return on the investments they have made. And we need to continue to be afforded that opportunity and not have that predicated on taking future policy-related actions. And again, we're committed to doing those, but just disagree with the notion of that new prudency standard being layered on top of that.
And the specific situation is MEA Witness Lombardi on pages 2 to 4 of her sur-rebuttal testimony said she recommends that if Pepco does not deliver on the DER roadmap and dynamic flexible interconnection or integrated data platform within 1 year of the order, recovery of the amortization of these projects should be paused until this condition is satisfied. So what is your reaction to that proposal?
Yes, for those reasons I just articulated, would disagree with that as an inappropriate form of a new prudency gate that does not exist today for recovery of assets that are used and useful for our customers.
Moving to OPC's sur-rebuttal, have you reviewed OPC witness Madsen's sur-rebuttal testimony, specifically beginning on page 15, line 14, when he discusses OPC's proposed operating revenue adjustment to the company's TTYCF?
Yes, I have.
And at page 16, line 19, does OPC witness Madsen argue that the company has misunderstood the purpose of his revenue adjustment, and that the purpose of his adjustment is to ensure that the revenue requirement best reflects the actual billing determinants that the company will experience?
Yes, I have reviewed that.
How do you respond to that?
I would offer that I think that represents a fundamental misunderstanding or mischaracterization of the rate setting process that we employ here in Maryland. I'll defer to company witness Nelson, and company witness Blazunas will be coming up over the course of the week to talk through how we determine our revenue requirements, how we set our rates. But I will note that OPC witness Madsen has advanced a adjustment to the company's revenues and stated that in the future the company is going to see more load, and so it needs to reduce revenues now in reflection of that load. That misunderstands the function of the BSA mechanism in Maryland. The commission adopted a BSA mechanism back in the 2008 timeframe to help encourage utilities to pursue energy efficiency. It delinked our revenue from usage, so as usage went down, our revenue would not go down. Things will operate the exact same way in the future. If we see usage and load going up, our revenue will not go up. We are decoupled from that usage link, and so I think his testimony that we need to adjust revenues for that dynamic misunderstands that construct. And if he is now characterizing this as a billing determinant issue, the appropriate remedy there would be to look at adjusting our billing determinants, not our revenues. So just find that to be a mischaracterization or misunderstanding of the rate setting process that our witnesses will discuss throughout this week.
On page 20, lines 10 through 14, does OPC witness Madsen allege that your rebuttal testimony offers no evidence that rebuts the 2% load growth increase that his adjustments is based upon?
Yes, I have reviewed that.
How do you respond?
I would, again, disagree that the company has not introduced any evidence to rebut that notion. In my rebuttal testimony, I specifically talk about a presentation that the Office of People's Counsel, Mr. Lapp, gave across numerous forums, but most recently saw him present to the legislature in Annapolis this past January. I've attached that presentation to my direct testimony as Schedule RTL-1-R. And on page 40 of that exhibit, I might just show it to folks here so we can see what it looks like. OPC has a chart of what Pepco's load forecast projections are going to be. So this is a schedule to my rebuttal testimony. It is RTL-1-R, and it's page 40 of 87 of that exhibit. Part 1. Apologies. I think I have it in both testimonies, but it's I'm referring to the one in part 1. And on this chart, what OPC is presenting is a projection of the Exelon Utilities demand projections in our PJM zones over the coming years. And there's a note in the middle of the page that says Exelon Utilities' current demand projections are less for 2029 than 2026. Growth projections decline between PJM's 2025 and 2026 forecasts. And they have a row for Pepco in the 2026 forecasts that notes our load is projected to go down from 6,003 megawatts this year down to 5,989 megawatts in 2029. So I would offer this as direct evidence that we have offered that show our load is expected to decrease, and OPC has stated this in numerous forums and is now contradicting itself by noting that we are going to experience a 2% load increase within the next calendar year.
Thank you, Mr. Lemming. I have no further questions for Mr. Lemming. He is available for cross-examination. And I neglected to mention, we are going to do Lemming Part 1 first, and then we'll go to Part 2 of his testimony.
Yep, that was in the list that way. Thank you. So we will go first to AOPA.
Okay, Your Honor, I don't believe I have anything on Part 1. I didn't
Okay.
do my cross that way. So could I pass to OPC and check my notes to make sure?
Well, let's go to, yes, absolutely, but let's go to MEA first.
Thank you.
Does MEA have,
Your Honor, I believe my cross also will refer to part 2.
very well. People's Counsel.
Thank you, Your Honor. I have a few questions specific to Part 1. I guess the complication, Your Honor, is that I planned for my cross to be for both parts, so I have a bunch of exhibits that cover both Parts 1 and Part 2.
We're doing a lot of separating and reconfiguring in this case, so we understand.
Okay. So what I can do, Your Honor, is if I may approach the witness, I'd like to just pass out the list of exhibits here, and I'll refer to them throughout my cross.
Certainly.
And these are both, there's a few that are specific to the exogenous costs regulatory asset proposal, which is covered in Part 2.
Okay.
So,
Watch out. And are these going into evidence? Okay. So OPC 1.
Here's what
OPC, okay.
just marked is direct. Part 1 and Part 2. Are you marking his rebuttal? And you're doing the Part 2 rebuttal and, okay. Don't have me get a heart attack here.
Did you bring your magnifying glass? Did you bring the magnifying glass?
I had to strengthen my prescription before the hearing. Okay. Mr. Lemming, good morning. Good to see you again.
Good morning. Good to see you as well.
So I'd like to first start with your direct testimony, Part 1 and Question 13. I think that's on page 6.
Yes, I'm there.
Okay. So here, on lines 11 through, so this question asks you to explain the rationale behind Pepco's application. Is that right?
That's correct.
And on line 11 through 21, you cite a few reasons that Pepco needed to file this rate case. Could you briefly explain those reasons?
Certainly, we note the company had last filed a base rate application in 2023, so about 3 years ago now. And since that time, walk through, the company's made a number of capital investments into the system, expects to continue to do so over the coming years. And really, these are things that we need to do in order to ensure we're addressing reliability, service quality, enhancing our customers' experience, supporting the state's clean energy goals. We talk about labor and environmental standards we need to comply with that drive some of our investments and operating plans, and that the current rates that we have in place today are not sufficient to be able to fund that work and provide the company an opportunity to recover those costs.
Thank you. And so Pepco's current rates, those were approved in case number 9702, is that right?
That's correct.
And those have been effective as of April 1, 2024? Does that sound right?
Yes, that's correct.
Do you recall what the company's authorized rate of return was when those rates were set?
I don't recall the authorized rate of return off the top of my head. I know from an ROE perspective it was 9.5%.
Okay. So does the number 7.13% sound right?
Subject to JEC sounds generally in the range.
Do you recall what the company's actual earned return was for 2024?
No, do not know that number off my head.
This information, both the authorized rate of return and the actual rate of return, was provided in Schedule RTL 2R-1. That's the very first piece of paper in the packet I passed out. Your Honor, I'd like to mark this as OPC Exhibit 1.
Without objection, so identified and entered.
So, Mr. Lemming, you see in the column labeled historical test year, the 12 months ending December 31, 2024. Right at the bottom there, there's the number requested rate of return, and right there it says 7.13. That should be line 33.
Yes, I do see that.
And then if you look up to line 28, that says the return on rate base. And that what's that number?
Sorry, which line did you point to again?
Line 28.
Line 28. This shows 7.3%.
So is it correct then that 7.3% is the company's earned return for the year ending in December 31, 2024?
I'm just taking a moment to look at this. I don't know that I would appropriately say that 7.3% reflected the rate of return that we earned for 2024. I'd have to go back and check what we filed within the docket in 9702 to validate this against. This was a presentation we prepared for the fully forecasted test year proceeding in terms of providing a completely historic test year point in time rate of return, a bridge year, and a fully forecasted test year that we have since withdrawn from this proceeding. Company witness Nelson actually includes a cost of service in this proceeding that demonstrates from a cost of service perspective that our rates were not sufficient to recover our cost of service.
Let me ask this way. So you've prepared these types of schedules before, is that right?
That's correct.
So just looking at what it says in the historical test year column, if you looked at that, would you agree that the data suggests the company earned above its authorized rate of return in 2024?
Without the appropriate context, I think one could take this to look at this to suggest that, but I would say under a traditional rate-making construct, which is what we're asking for consideration of here, this schedule does not reflect all of the rate-making conventions we would employ under traditional rate-making that could demonstrate different results, and company witness Nelson has those results in his testimony.
Understood. So now look at the column for 2025, the bridge year, under the company's parlance. Now, if you looked at the data in this column, would this indicate to you that the company under-earned in 2025?
This would indicate to me that the company expected at the time it filed its application that it would be under-earning in 2025. The bridge year is forecasted information in this proceeding that we have withdrawn for consideration.
And the company's expectation that it would under-earn in 2025, is that one of the factors that helps influence the company's decision as to whether it needs to come in for a rate case?
That would have been a factor at the time we considered this case, but I would note this is all presentation of forecasted information that we filed at the time of our proceeding and have since withdrawn. Company witness Nelson also has the traditional view of information based on a historic look of our rate-making results that show that we were under-earning as well, so that was another consideration for ours at the time that we filed.
So it's your testimony that all of the data for the bridge year in this column here, in your rebuttal testimony that you filed, that was all forecasted data?
Yes, in my Part 2 testimony that I had filed in this proceeding, 2024 was all actuals, 25 was, and 26 were projected.
And the company didn't update those numbers in its rebuttal testimony, based on the company's the known data the company had available to itself from its performance in 2025.
I think we did update some numbers, but we did not do a wholesale update to actuals of the bridge year.
Okay, thank you. Now, Mr. Lemming, how familiar are you with Pepco's overall financial performance from 2023 to 2025?
Somewhat. I think it would probably depend on the specifics of your question and the nature of what they get into, but generally have awareness of our financial performance.
Understood. So the next document in the packet I passed out is an excerpt from Exelon's SEC 10K filing, which was filed earlier this year in February 2026. And I'd like to mark this as OPC Exhibit 2, Your Honor.
So marked and entered. Just mark it.
Now, you'd agree, Mr. Lemming, that the cover page of this document reflects that it is from the 10K for the year ending on December 31, 2025?
Yes, that is correct. That's the period this is for.
And if you turn to the last two pages of this excerpt, you'll see that there are signature pages, each dated February 12th, 2026.
Yes, that is correct.
And one of these signatures is for J. Tyler Anthony, who is Pepco's CEO. Is that right?
That's correct.
And the other signature is for Elizabeth Morgan Downs O'Donnell. And,
Yes, that is correct.
And these signatures are on pages attesting that they've reviewed the annual report and that the report, based on their knowledge, does not contain any untrue statement of material fact. Is that right?
Yes, I believe that's the general. I haven't read through every disclosure specifically, but I believe that's the general notion of all these disclosures on these pages.
And are you familiar with what a 10K filing contains?
Yes.
And so you'd agree that it reports the financial performance of Exelon, among other things, and each of Exelon's affiliates, including Pepco?
Yes, that's correct.
And to your knowledge, this 10K filing is required to be submitted annually by law. Is that right?
Yes,
Objection. This is not within the witness's purview of his testimony.
If I may respond, I'm laying a foundation to demonstrate the authenticity of this document, that the numbers contained within the document are likely accurate, and the purpose that I'm discussing this document with Mr. Lemming is to draw a contrast into Pepco's stated needs for raising its rates now and the company's financial performance over the past several years.
I'll allow it overruled.
Thank you. So, Mr. Lemming, do you have any reason to doubt the accuracy of the numbers that would be contained in the 10K?
No, I do not have a reason to doubt their accuracy.
Okay. So if you turn to the next page, this is page 141. And apologies for the small print. I could not blow it up as best I tried. Here, there's a line that relates Pepco's net income. It's, I think, the second line up from the very bottom.
Yes, I see that.
And would I be correct to define net income as reflecting the company's total profit after deducting operating expenses, including taxes, interest, and depreciation?
Yes, this is for the consolidated Potomac Electric Power Company, so that includes our company's entire operations in our transmission business, our utility operations here in Maryland that we're here to talk about today, as well as our operations in the District of Columbia as well.
Understood. Do you know approximately what Maryland's jurisdictional allocation is?
Of what specifically?
the load allocation? Like how much of Pepco's load, distribution load is Maryland responsible for?
I do not know that off the top of my head. We use a number of different allocation factors across our cost of service that kind of dictate how we allocate all various different, whether it's component of the plant, operating income, operating expense. I don't know all those off the top of my head specifically.
Okay, understood. So I'd like you to take a look at the column for 2023. Is it correct that here the 10K shows that Pepco's net income was $306 million?
Yes, that's correct.
And for 2024, does the filing show that Pepco's net income was $390 million?
Yes, it does.
And for 2025, does the filing show that Pepco's income was $401 million?
Yes, it does.
So over these 3 years, the company was able to grow its profits by by nearly $100 million. That was $84 million from 2023 to 2025, and then $15 million from 2024 to 2025.
I believe it's 11 million from 24 to 25. So
11 million instead of 15 million from
yes.
2024 to 2025. And to your knowledge, would the rate increase from authorized in case number 9702, would that be a contributing factor to the $84 million increase in net income from 2023 to 2024?
It would have been a contributing factor to the operating revenues included in here. And then on the I guess, counter to that on the operating expense side, you'll see the effect of the increase in our operating expenditures and operating costs over that period as well, that those revenues were authorized to recover for.
So if the company's operating revenues for increase from 2023 to 2024, and it looks like they did, the company's that increase wouldn't be reflected in the increase in net income as well?
I mean, net income is a function of revenues minus costs. So for Pepco Maryland, it would be a component, but it wouldn't be necessarily the one and only direct driver of net income. You have operating deductions such as our tree trimming expenses, our payroll expenses that we make as well, and each of those would have contributed to net income as well.
But so you'd agree with me then that the operating revenue increase resulting from case number 9702 would be a contributing factor to the $84 million increase in net income. There's other factors, I acknowledge that, but it would be a contributing factor.
It is a component of that number, yes.
Okay, thank you. Now, to your knowledge, from 2023 through 2025, did Pepco issue dividends to its shareholders?
Objection. Again, this is outside of the purview of Mr. Lemming's testimony, either direct or rebuttal. So objecting on relevance grounds.
Your Honor, for the same reasons that I offered the 10K and laying the foundation for it, I think the amount of dividends that Pepco has paid its shareholders is relevant to evaluating the true need for Pepco raising its rates in the near term.
I guess I have to allow at this point, don't I? Overruled.
Now, if you turn to the next page of this document, Mr. Lemming, that'd be page 142. There's a line about 3/4 of the way down. It says dividends paid on common stock. If you could locate that line and let me know when you're there.
Yes, I see that.
Okay. And so for 2023, you'd see that Pepco paid $252 million in dividends to shareholders. Is that right?
Yes, that's correct.
And for that number for 2024 is $359 million. Is that right?
Yes, that's correct.
And for 2025, the number is 327 million.
Yes.
Okay. Now, subject to check, would you agree that the total amount of shareholder dividends issued from 2023 to 2025 is $938 million?
I don't have a calculator in front of me, but would subject to Jack agree that's in the ballpark, and would just note that that's the money that went up to the parent company, Exelon Corporation, and much of that ultimately gets offset by, on the following row, you have a contributions from parent that we use these cash flows to kind of balance our capital structure, which company witness O'Donnell can speak to more as she comes up. But just want to note, I think you need to look at these two rows on a net basis to understand what our true equity positions were between Pepco and its parent company in total.
Okay. Well, let's take a look at the contributions from the parent. For 2023 to 2025, I've done the math, and it totals 761 million. So, subject to check, would you agree with that number?
Subject to check, it seems about in the neighborhood of these numbers.
So if you subtract the $938 million in dividends that Pepco has paid its shareholder, and from the 761 million that Exelon has given to Pepco, the net is around $177 million. Subject to check, would you agree with that number?
Yes, over a 3-year period, so that's probably in the ballpark of $60 million a year, and that's the dividend that we pay on the amount of invested capital into Pepco that hasn't been invested, which I believe is in the neighborhood of $2 billion on behalf of our equity holders.
And so this $177 million number over the past 3 years, that's about more than $50 million more than the revenue requirement increase Pepco is seeking here currently.
I'm sorry, can you repeat that question one more time?
So the 177 million in dividends that Pepco has paid to shareholders, when you net out the difference between the stock shareholder dividends and the contributions from the parent, that $177 million number is more than $50 million greater than the revenue requirement Pepco is asking the commission to approve in this rate case. Is that right?
I mean, I guess I don't see the relevance in the comparison, but yes, that I'd say that is the difference in those two numbers. But I think you're comparing apples and oranges in that question. So just note that.
Understood. Noted. And so, despite it looks like, from the 10K, would you agree that the company's seems to be doing fairly well financially?
I don't know that I can deduce that from what we just walked through here. Again, the company here in this proceeding is Pepco Maryland. We're looking at our Maryland utility operations for distribution here. And we have information in our record that demonstrates for the services and the operations that we're undertaking for our customers in the state of Maryland, that our rates are not adequate right now to recover our cost of service, as well as earn a return on the invested capital that we have in our business. As I was noting earlier, as you're looking at these dividend numbers here, we're and again, I don't have all the numbers in front of me, and I think it would be best for our Chief Financial Officer, Witness O'Donnell, to probably speak to some of these things. One of the provisions that I talked about earlier from a cost recovery standpoint is us being awarded an opportunity to earn an appropriate return on our invested capital, and that's what a dividend to some extent represents. And so as you look at that $60 million a year relative to the billions that are invested in our business, I think we have a demonstration through company witness Nelson's testimony that for Pepco Maryland operations, we are not fully recovering those costs and having that opportunity to earn that return.
So I'd like to ask you about the next document that I have in the packet. This is an excerpt from Exelon's Spring 2025 Investor Meeting presentation. And Your Honor, I'd like to mark this as OPC Exhibit 3.
So marked. Which page are you on?
Not on a page yet, Your Honor.
Oh, the whole document. Okay.
And OPC asked a data request about some pages from this document. This would be data request 24-23, which is also the next page in the packet that I handed out. And Your Honor, I'd like to mark OPC DR 2423 as Exhibit 4.
So marked.
And Mr. Lemming, you sponsored the responses to OPC DR 24-23?
Yes, I did.
Okay, thank you. So if you could turn back to the excerpt from the investor meeting presentation, turn to page 19, please. I think it's the second page. Now, this page here notes Exelon's 2024 to 2028 earnings per share growth target. That target's 5 to 7%. Is that right?
Yes, that's what's on the left side of the page.
And your response to OPC DR 24 or 2423 subpart C confirms that you were aware of this target at the time Pepco's rate application was being prepared. Is that right?
Yes, I was aware. I'll just note that's an Exelon Corporation target, so that includes a number of factors, including all of our affiliates across the U.S., transmission businesses, gas businesses, et cetera, of which Pepco Maryland's distribution utility operations are just one small component of.
Understood. Now, to your knowledge, can you explain what earnings per share represents?
Certainly, it is the level of earnings that are available after you look at the operating income that has come in through to Exelon, and you've deducted all of the company's operating expenditures, its financing expenditures, the level of earnings that remain to investors in the company. And again, company witness O'Donnell is probably the best to speak to this as the company's chief financial officer, but the form of someone's ownership in the company is expressed in they hold a share of the stock, right? And so if you have, $1 million outstanding, and if $1 million in earnings, and you have 1 million shares outstanding, it's expressed as $1 per that share of stock that you would own in the company.
And so, just to kind of simplify it a little bit, earnings per share, that's derived from taking the net income and dividing that by the total number of outstanding shares for Exelon. Is that right?
That's correct.
And at a high level, there's a couple ways that earnings per shares can be increased. Would you agree that Exelon as a whole increasing its profits, the amount of outstanding shares remaining stable, an increase in profits would result in an increase in earnings per share?
Yes, certainly.
And then conversely, if income doesn't increase and Exelon buys back some of the outstanding stock, that also could result in an increase in earnings per share.
Mathematically, yes, that's how that would work.
And you're not aware of any Exelon plans to buy back outstanding shares at this time?
That is not an area of information that I have. I don't work in the company's treasury or finance department.
Okay. So would you agree that one way Exelon could increase its profits is by Pepco increasing its net income?
Yeah, I'm going to have to object here. This witness is, not the person to be speaking about this. He's referred to Ms. O'Donnell a few times in his answer. So again, objecting on relevance grounds.
If I may respond, Your Honor?
Certainly.
I believe Mr. Lemming has a master's degree in business administration, is that right?
That is correct.
And I'm asking just generally about very high-level conceptual matters about what earnings per share represents and how Pepco's business fits into that of its parent company. This should be questions that Mr. Lemming should be able to answer to his knowledge.
Well, I think I agree with the company on this because I think the objection is sustained because earnings per share calculations are actually not that simple. There are a lot of factors having to do with dilution and anti-dilution, which I would not expect a person with a general degree in business to be able to answer. So, sustained.
Mr. Lemming, Pepco's profits are largely tied to capital investment in its distribution and transmission systems. Is that right?
I'd say our net income is driven by a number of factors that include efficient operations of our business, our load on our system. To the extent our revenues include an opportunity to earn a return on our invested capital, that would be taken into consideration as we come in for rates to be set by the commission in a rate case proceeding.
But the only item that Pepco earns a rate of return on is its capital investment. Is that correct?
From a revenue requirement calculation perspective, that is a driver of that, but our ultimate profitability is influenced by our revenues and operating efficiencies and dynamics in terms of how we spend our money on a day-to-day basis to operate our system.
So all else being equal, say O&M remains flat. If Pepco increases its capital investment and that leads to increased plant additions, would that increase in rate base be a key factor in Pepco increasing its profits?
If Pepco filed for a rate application and demonstrated to the commission that it had invested capital and that it was prudently invested, and the commission found that a reasonable return on that would result in a rate increase to the company, then yes, under that hypothetical, that is how that would materialize.
Okay. When operating under a stated rate, when new capital investments are placed in service, is it correct that Pepco does not immediately earn a return on and of those investments?
Yes, that's correct, which is why I kind of noted we have to file a rate increase for that.
Yeah, and that was going to be my next question. So for Pepco to minimize the period of time when it makes new capital investments, to minimize the period of time when the return on and of the capital investments are not being recovered, the company would need to file a change in its rates. Is that right?
That's correct.
And your testimony at page 6, lines 11 through 13, notes that Pepco's made $300 million in capital investments since 2023. And is Pepco currently earning a return on all of those $300 million in investments?
I do not think it would be accurate to say we are earning a reasonable return on all the capital we've invested. To your point, since we last had rates set in April 2024, we have put plant into service, made investments that were not considered at the time that our last rates were last set. So those are subject to what you were describing. We were talking about as regulatory lag. And company witness Nelson's revenue requirement would capture, what that asset basis looks like and what the deficiency is in revenues to earn a return on them at this point.
And so for Pepco, to your point, for Pepco to earn its return on those investments, it has to file for a change in rates.
That's correct.
And if new rates are authorized, then Pepco's revenues would likely increase. Is that right?
Sorry, can you say that question one more time?
If new rates are authorized, would Pepco's revenues increase?
Well, I think OPC is advocating for a decrease in this proceeding, so I think it determines what the commission ultimately rules in terms of a just and reasonable rate coming out of this proceeding.
Let me rephrase my question. If Pepco's proposed rates are authorized, would Pepco's revenues increase?
Yes, they would.
And would it be fair to state that if Pepco's revenues increase, it's likely that Pepco's profits would increase too?
It is certainly a potential. We would have to, manage our costs and investments, and I'd say mostly our costs, but our investments, as we have to issue financing, bring with it increased interest expense, things like that. If we were able to continue to manage our costs in an effective manner, such as we have done over recent years, we should have that opportunity, but it's not a guarantee.
And if Pepco's profits were to increase, as you understand it, would that help Exelon achieve its 5 to 7% earnings per share growth target?
If Pepco was able to increase its net income, that would be a contribution to Exelon's overall net income.
Thank you. Now let's turn to page 7 of your direct testimony.
This is part 1 still?
Yeah, still part 1. I don't think we've got to part 2 yet. And if you could take a look at line 6, there you note that Pepco recognizes that rising costs are a significant concern for customers. Is that right?
Yes, that's what that says.
And if you scroll down to page 16 of your direct testimony, starting at line 16, there you note that Pepco's customers are facing a range of economic pressures and uncertainties, including energy costs. Is that correct?
Yes, that is correct.
And then you identify and discuss, starting at page 20, line 15, measures that Pepco has taken to enhance customer value and help lower costs. And here you discuss, quote, balancing the need for continued investment, end quote, with, quote, a variety of measures to enhance customer value and lower customer costs. Is that right?
Yeah,
page 20, line
that's
15.
Line 15 through 17, or through the bottom of the page. That's what that discusses.
Now, the measures that you identify include maintaining O&M costs below inflation rates, engaging with customers on energy efficiency, and energy assistance programs. Is that right?
Yes, I mean, that's what I say on page 20, but I think my testimony in the following sections get into much more detail on the types of things that we do to assist customers.
And so Pepco doesn't earn a return on its O&M spending, right?
No, we do not. I think one of the measures that we've looked at to help manage customer costs is looking at our rate of investment, and it's discussed in company witness Allo's testimony. Since our last rate application, we've actually looked to reduce our rate of capital expenditures by about 15 to 20%, depending upon the year. So that's an additional measure that we've looked at in order to try to help manage bills that get to your point, what we earn a return on.
Okay, but just my question was about O&M. So O&M you don't earn a return on, right?
No, we do not.
Okay. And Pepco's rates, they're decoupled. I think you stated that earlier. Is that right?
That is correct.
So if customers increase energy efficiency, Pepco's rates are adjusted through the BSA mechanism to ensure that the company continues to earn the revenue requirement that it was authorized. Is that right?
That is correct.
So you'd agree that Pepco's profitability is not significantly impacted by customer energy efficiency efforts.
Our profitability is not what I'm discussing here. Is the ways that we help customers understand what they can do to effectively use their energy to bring their bills down, and energy efficiency is a very critical component of that. Right now, supply costs are dramatically increasing, right? And so if they can bring their usage down, use less supply, use less commodity, they can save on their bills, and that's something that we work very hard with our customers to make sure they understand and can take advantage of those opportunities to save on their bills.
And the energy assistance programs that you also refer to, those are programs that help people afford their bills, right?
Yes.
Do those programs they help people so they can pay their bill to Pepco?
That's correct. I think we talk about other assistance we try to connect folks to with respect to other components of day-to-day living they have that through single stop that company witness Vosvik discusses in his testimony. We try to also help connect them and educate them on those opportunities of where they can seek assistance as well to help maximize the impact we can get to customers.
But would you agree that if those programs are working properly, at the end of the day, Pepco's made whole because customers can pay the full bill that the full amount they've been charged by the company?
I guess that's a bit of a hypothetical in terms of, you say, if they're working properly. I believe that's an objective of state assistance programs and assistance programs that we offer. But one of the challenges on customer bills right now is the dramatic increase that we're seeing in supply costs, which we do not control and do not profit from, and that is probably the single largest contributor to customers' bills right now that they are struggling with, and we are seeking to try to help them with. And I don't know that all of the assistance programs out there fully address that dynamic right now.
If you could turn to page 21, line 9 of your testimony. And at line 9, this starts a discussion of how Pepco assists customers in management of energy costs. Does that look right?
Yes, I'm there.
And so in your testimony here, you discuss directing customers towards opportunities that help improve their energy efficiency or provide bill payment assistance. Does bill payment assistance and energy efficiency directly affect the distribution rates that Pepco charges its customers?
I'd say bill payment assistance in terms of if we can help keep customers in service and reduce the amount of ultimate arrearages that would get written off, that would affect our bad debt expense, that if that amount keeps going up, that would increase our distribution costs and be passed along to customers. So this to the extent we can help keep customers from defaulting on their balances that are past due and having that increase our bad debt expense, that is a savings for our customers in general.
But the reason the customer would be defaulting on their past due balances is because of their inability to pay what Pepco's charged them. Is that right?
Yes, the largest component of which is the supply side of the bill, which we do not control and has been increasing meaningfully over the past several years and is much of the focus in the energy policy space these days.
Understood. Well, I'd like to ask you about the company's response to OPC DR 35-1. And I'd like to mark this.
Is that in the packet?
Yes, it is in the packet. And I'd like to mark this as OPC Exhibit 5, Your Honor.
So marked.
And Mr. Lemming, if you could turn to subpart C. Well, first, just establish, you sponsored this response to the DR, correct?
Correct.
So if you could turn to subpart C. This question asks if Pepco agrees that households and businesses across Montgomery County and Prince George's County also face significant financial pressures.
I'm going to object. The purpose of this DR references a rate case at Pico in Pennsylvania, a Pepco affiliate, and therefore is not relevant.
If I may respond, Your Honor, I'm asking about Subpart C. The company didn't lodge an objection to Subpart C.
Yeah. Overruled.
And so the company's response to Subpart C here states that Pepco recognizes customers in Montgomery and Prince George's County face financial pressures related to supply price increases and other inflationary impacts on goods and services. So what do you mean by supply price increases here?
Certainly, within the PJM region right now, we're experiencing a resource inadequacy situation, which has resulted in a significant increase in energy, electricity, commodity prices in recent years. That has had a significant impact on our customers, right? We have seen significant generation retirements across the state and across the PJM region with inadequate new supply coming on to offset that. We've seen a significant increase in load across PJM from electrification, data centers, et cetera, coming in that is driving the cost of power prices higher. For Pepco specifically, we've seen over a 50% increase in our supply prices in the past several years that are the largest component of customer bills. And so when you look at the biggest component of their bill going up by over 50% in a short period of time, that has placed a significant burden on our customers that we are working very vigorously with policymakers, with our customers, with the state, to try to figure out how we can help get our arms around these challenges, get these costs under control, and help our customers out during these times where we're struggling with these costs.
So to state it simply, the supply price refers to the price of the electricity that Pepco delivers. Is that correct?
That is correct.
And so that excludes Pepco's distribution rates, correct?
Yes.
So is it your testimony then that the only financial pressures Montgomery County and PG County customers face concern increases in the price of electricity and the price of cost and goods, and not distribution rates?
No, I think I say here increases and other inflationary impacts on goods and services, and so I'd say our distribution service is one of those services. I talked about the period in time where supply prices have gone up over 50%. Our distribution services have gone up about between 4 and 4.5%, which is closely tracked with inflation over that period. So I'd probably describe that as an inflationary service that we offer.
Now, if you could take a look at the response to OPC DR 24-13, that's the next DR in the packet. And Your Honor, I'd like to mark this as OPC Exhibit 6.
So marked.
So here, you sponsored this response, is that correct?
That's correct.
And here you agree that rising electric distribution rates are an economic pressure that Pepco's customers face, is that correct?
Yes, that's correct.
So would you agree that one of the most directly impactful actions Pepco could take to address customer affordability in the near term would be to mitigate the extent its rates would increase?
I believe that is an impactful measure, and that is what we have strove to do I'd say in recent years, and really all the time it's what we strive to do. In order to mitigate the size of those increases, we manage our O&M lower than the rate of inflation. We always look to identify efficiencies to bring our costs down. As I mentioned earlier, we've looked at our capital portfolio since the last time we filed a rate case. We've looked to bring that down by the range of 20%. We're looking at things like in our Drive Act proceeding, where we're looking to bring peak demand on the system down to try to avoid unnecessary investment in the system. We're looking at ways to offer assistance programs, like I said, to help keep our bad debt expenses down and help really I think most importantly, get the assistance out to our customers that we need. But those actions that we can take can only go so far, and they can't fully mitigate the impacts of the economic realities of inflation and rising prices that we have to deal with as well and contend with as well. And so while we've strove to keep the size and impact of our increase down as much as we can, we are not able to fully offset and obviate the need for that request here.
So despite the nearly $100 million increase in Pepco as a whole's increase in net income, despite the $900+ million in dividends that Pepco paid to Exelon, it's the company's position that a $119 million revenue requirement increase is absolutely necessary and the most that it can do to help manage affordability concerns?
Yes, as I've noted, we do not take what is going on with customers lightly now, but we ultimately need to ensure that we have a viable utility to continue to offer them service over the coming years. And we are at a point where, I've talked about actions we've taken to keep O&M lower than the rate of inflation. We've implemented a number of austerity measures that we've talked about with the commission over the past year, where we've gone into managed hiring processes to curtail the impacts of that on customers. We've reduced our capital investment. We still have to ensure that the utility is viable and has the cash flow that is necessary to continue to provide service to our customers. Otherwise, we're looking at a situation where they could have other higher costs, right, if reliability was to suffer, if we weren't able to connect them with those assistance opportunities because we were short-staffed and couldn't keep up with our programming on those things. Those are all things that would come back in the longer term to increase costs for our customers. And so it's always a delicate balance in terms of managing a rate increase for customers versus ensuring the viability of the utility. And we work very judiciously to strike that balance, but ultimately we're at a point now where we've determined it's necessary in order to be able to continue operating at the level we need to seek that increase.
Thank you, Your Honor. That's all the questions I have for Part 1. I'd move for the admission of OPC Exhibits 1 through 6.
I object to Exhibits 1 and 3, objecting to 1 on the basis that schedule is part of the schedules that we took out of the FFTY, and it's no longer in this case. And I object to the entrance of OPC 3, that was the investor meetings. This is an excerpt. If OPC has the entire investor meeting presentation, that could go in, but object to just the excerpt.
If I may respond, for OPC Exhibit 1, I offer this exhibit to establish that Pepco over-earned for 2024 and under-earned for 2025. I didn't ask the witness any questions about the FFTY, and I think the cross-examination that I put forth demonstrates the relevancy of this exhibit. As for Exhibit 3, we have a full copy of the investor presentation that we can present to council. It's fairly lengthy, and I didn't want to hand everybody a 75-page document. But we're happy I can produce that exhibit right now, and I'm happy to have the whole investor presentation entered.
With respect to number 3, do you accept that as a...
I do accept that, to have the entire presentation in.
Okay, and with respect to number 1,
Excuse me, Mr. Chairman, could staff be heard about that?
absolutely.
When we sat down, we got handed this from council. Thank you very much. I'm good, but I'm not that good. So I don't, when this is what they filed today as their updated Lemming 1. We've already heard from parties that this is a little messy. Something was filed Friday night. O'Donnell's testimony didn't redline any FFTY. material. Maybe it was an oversight, maybe it was just too hard to do. But I don't think that saying that we can't have a question in or evidence in because it's that part of FFTY of the case, because that I wouldn't want that said to us. We have our questions prepared and we're trying to stay within TTYCF, but did it go into something that they redlined or should have redlined or just redlined and we didn't know till today? I think that's just unfair.
Okay, well, so what do you, are we?
Let it in. Pardon me, I'm sorry. I'm sorry.
This is OPC 3 you're referring to, right?
Yes, sir, thank you.
Oh,
one, I'm sorry, one. Yes,
Oh,
I'm
one.
sorry.
Okay. Yeah, I think we should just let it in. So, the motion then is to accept one, two, the full number 3 and through 6, right?
Oh, the PICO DR, which was,
Which one was that?
that was OPC 5.
Okay.
A counsel for OPC only refer to question C, the answer to question C. As I mentioned, that entire DR refers to PICO, which is an affiliate. It's not relevant to this case. So we would object to 5 going in. C, since he asked questions about that one, would be appropriate to go in, but the remainder we would object to.
If I may respond, Your Honor. Well, first, I reject the premise of counsel's statement that an action that PICO took is completely irrelevant. The PICO action, this is the withdrawal of its rate case citing affordability concerns. PICO, like Pepco, is a subsidiary of Exelon, so I'd assume that Pepco would be aware of actions that other affiliates are taking. So just as a general matter, the basis of our DRs is relevant and sound. That said, I'd accept counsel's, I'm fine with subparts A and B not going into the record, but the company didn't object to subpart D, and that should go in.
Subpart, what was that last?
Subpart D, Your Honor.
Yeah, oh, okay. So you're agreeing to C by itself?
My preference
And D?
is, yeah, C and D, that's correct.
Okay. My hearing is starting to go here. I wasn't sure if you said C or D that last time, but okay, okay. So that seems a reasonable stance. So we are admitting basically everything except for A and B in OPC 5. Okay.
No objection.
Okay, so it is.
Your Honor, all of my questions go to part 2, so I need to hold those.
Right, we haven't addressed that yet, so, right. Okay, no, wait, is Montgomery County, do you have a cross? You don't? Okay. Staff then.
Thank you. Oh, MEA, yeah.
Oh, I'm sorry, forgive me, MEA?
I'm sorry, we realized we do have questions related to part 1. I don't know if you want.
Yeah, go ahead, it was my mistake.
No, there was somebody joined there and related issues, so we.
Well, go ahead. That was just my mistake, so. Do you want to come up to the table?
Sure.
Yeah, let me, you know what, it's 12:05. I'd like to take a quick 5-minute break. We're back. All right, we will go to MEA.
Thank you. Hello, Mr. Lemming. How are you?
Hello, good. How are you doing?
I'm doing well. I do have a question for you first regarding your live rejoinder this morning. There you said Pepco is willing to commit to working with MEA on a number of forward-looking initiatives, but noted that they should not be time-bound. Is that correct?
Yes, I mean we'll certainly do everything in our power to advance things as quickly as we can and look for opportunities in the next year to do things. But just noting, I think there was some discussion of like in Pepco's next rate case or things like that. One of the things we need to be able to take into consideration is impact to customers and impact to the company from a cost recovery standpoint. And just would want to make sure we have, a degree of flexibility in there to accommodate those considerations, but are very committed to generally trying to stick to timelines around what MEA has proposed.
So is Pepco willing to, I heard you mention in your response here 1 year, so is Pepco willing to commit to concrete timelines for any of the programs mentioned by MEA, such as the non-wires solutions framework, dynamic flexible interconnection process, or statewide data sharing platform?
Yep. So we thank you for that question. I think in examples we have the DSP distribution system planning, or I think it's evolved to electric system planning. Filing that needs to be made in June. I think that's an area we would definitely like to talk with MEA, and again, any stakeholder we're always happy to talk with about what we might be able to include in that filing around frameworks. We've got storage procurement filings coming up in I think it's November timeframe of this year. So I think that's another milestone that we can look to collaborate towards. So I think all of these have avenues within the next year that we can work with MEA on and are very interested in doing so. I just ultimately just have a little bit of the caveat that it ultimately depends on how commission dockets work out to determine if we can get some of those in or not. So I don't foresee a reason for delay, but timelines have changed at times before.
Okay, thank you. I'm going to ask you some questions related to the White Flint project as discussed in part 1 of your rebuttal testimony. Do you have that?
Yes, if you could just, as you're going through, kind of point me to where you are.
Sure.
Have that with me.
Please turn to page 26, lines 23, to page 27, line 2 of your rebuttal testimony, and I am referring to the April 24 page numbering.
Yes, 1 second. All right, you said page 26.
The last line there, line 23.
Okay.
And to the next page until line 2. There you state that, quote, White Flint represents a prudent investment selected to avoid more disruptive and expensive alternatives in a constrained area. Do you see that?
Yes, I do.
So, in addressing expensive alternatives, what alternatives are you specifically referring to here in your rebuttal testimony?
I'd have to defer to company witness Allo and the alternatives analysis he has sponsored in his testimony. I'm not a system engineer that can speak appropriately to the alternatives analysis that we've gone through, but I know in general, right, we go through alternatives analyses and strive to select the lowest cost alternative that will provide the best fit at addressing the solutions, and we went through that process with respect to the White Flint substation.
So would you know how much the cost of those more expensive alternatives were?
I personally do not. I'd rely on our system planning folks and company witness Alo's organization to advise me of that.
Okay. Did Pepco perform a quantitative analysis comparing the cost of the alternatives referred to in your rebuttal testimony to the cost of the White Flint project?
Again, I'll defer to company witness Alo. I think he's got this information in his testimony. I would flip to it if I had it to kind of show where we've gone through alternatives analysis. But I do recall having seen that there were alternatives considered, price cost determined on those alternatives that were a part of the decision making on the project.
Okay, so I will address those with Mr. Allo then. I do not have any further questions relating to part one of your testimony. Thank you.
Thank you.
Thank you very much. Let's proceed then to, I believe Montgomery County didn't have any cross, so we'll proceed then to staff. I just want to make sure, the court reporter, you had the witness's name? Okay. Ms. Herman, proceed.
All of our questions, we believe, are lemming too. And again, what I said earlier, there's been so much crossing out and, just handed, but thank you. We believe they're all lemming too. I just don't want to be held to it, and so I thank you for your indulgence.
Noted. Alrighty then, in that case, I believe we will, pardon me, redirect.
Thank you, Chair. Just one question on redirect. Mr. Lemming, you were presented with OPC Exhibit 1, and that is entitled Rate-Making Results, Distribution Only for FFTY.
Yes.
Is this presentation useful for a TTY, a traditional rate case?
No, the intent of this presentation was to demonstrate what a revenue deficiency would have been on under a forecasted test year approach. Company witness Nelson maintains the schedules that would be useful for determining a revenue deficiency under a traditional test year.
Thank you. I have no further questions.
No further questions. All right. In that case, we will proceed to the members of the commission. We're going to go in the following order, and I'm going to be rotating this as we go forward. But initially, to start, Linton, Suchman, Hoover, McLean, and the chair in that order. So, Commissioner Linton, do you have any questions?
Yes, thank you, Mr. Chairman. Good afternoon.
Good afternoon.
So I'm pointing to your direct testimony. It's really a theme throughout your testimony, but I'm focusing on pages 8 and 9, and there's a bit of a spillover into page 10. It's fairly obvious that the company prefers a fully forecasted rate model as opposed to historic test year. So in our evening hearings that we attended, they were virtual, but we attended 2 of them. We heard from a number of consumers, and it was striking to me that they were not only, in many cases, opposed to a rate increase, but they were opposed to the specific form of rate increase. And these are what I would consider to be ratepayers, laypersons, who were specifically identifying the concept of a forecasted model, be it MYP, fully forecasted, etc. So my question for you, in light of the fact that the company is very supportive of the concept, and you clearly prefer that over historic test year, do you believe that the fully forecasted model has been beneficial to your ratepayers?
Yes, thank you for that question. I would say at the outset that I'd say I was surprised as well to hear members of the public that in tune with rate-making processes before. It's not something I had traditionally observed in talking with members of the public. But I think this conversation was something that was very present in the legislative session, and I think folks started talking much more about it and has raised awareness around it, which in general I think awareness is a good thing and probably presents an opportunity for us as a company to perhaps think about how we can engage and educate with the public on this. But to your direct question, I would say yes, I think forecasted test year rate making has been beneficial to our customers as we kind of look at things. You know, we've been long advocates. I know folks have heard from us talking about MYPs that use fully forecasted test years. We've been able to provide transparency to not only the commission, but also stakeholders and the public in terms of what we are planning to do operationally, investment-wise over the coming years, and what the resulting impacts are going to be from a rate perspective of that. The commission has been able to ultimately use that information in its deliberations. And I can speak to Pepco, but I know from my general experience, all utilities that have had forecasted test years approved, the commission has looked and said, you know, these investments look great. Perhaps there are some that we don't fully support, but we observe the impact of these is going to be too great for customers, and they've directed the utilities to slow down or revisit either the pace of investment or the sequencing of investment to mitigate bill impacts for customers. And one of the things we've been able to actually observe in doing that is that under traditional test year rate making, where you're looking at costs after they're in service and fully baked, we were seeing higher impacts to customers before we had this kind of proactive conversation and feedback from stakeholders about what the bill impacts were to customers. And as we were able to have this kind of deliberate input into our spending plans before they happened, we actually saw the rate of our authorized distribution revenues, the rate they were growing at, actually moderated and came down once we started to have this advanced conversation about investments before they happened. And so I think that's definitely a direct benefit that this mechanism has provided to our customers.
Okay, so you initially filed this one as I said earlier, as a fully forecasted test year, and just in general filed your rate case back in October. But as and I forget the number, I think it was OPC Exhibit 5, referenced that one of your subsidiaries chose not to file. We know that in Maryland, at least, Baltimore Gas and Electric also delayed their filing. When I look at the response from the exhibit, I looked at your direct testimony. I was looking for things that were unique to Pepco that didn't necessarily impact the other members of the Exelon companies that made a different choice in terms of proceeding with this case here. Keeping in mind that very recently the Maryland General Assembly actually passed a bill that limited your case and your filing, converting it in a way that, based on the testimony at least, you clearly didn't prefer. So help me to understand what's unique for Pepco that doesn't impact everybody else, that's making it necessary for you to proceed while other companies have chosen something different.
You know, I'd say there's probably a few different dynamics at play, and again, you know, hope I was clear on this point, but we never take a request lightly, right? We know that bill pressures are real for customers. We know that with the supply constraints that we're under right now, folks are acutely feeling the impacts on their bills as they're kind of seeing more volatile weather experience, higher power prices hitting their bills on a day-to-day basis. And we are working very diligently to help try to get our arms around that. But we've got to strike a careful balance, right, in terms of what we need to be able to maintain our health and continue to provide service to customers. I think, you know, a few differences I'll perhaps note between the utilities is Baltimore Gas and Electric and Pepco were both operating at the time we elected to file our case under forward-looking constructs, right? Pepco had received a forecasted test year increase in their last case, so they were getting more contemporaneous recovery of their investments. BGE is currently operating under a approved multi-year plan by the commission. Pepco did not. We had a stated rate put in place that was effective as of 2024 in our last proceeding. So we've been, I think, subject to a different degree of regulatory lag than the other utilities have. So that's one distinguishing factor that we've had to manage that I think makes us a little different than those utilities. But I think an important consideration also is we've looked at that announcement that came out from Pepco last week about their withdrawal, and I think an important thing is it doesn't negate the need for that increase, right? Pepco's ultimately going to need to come back in and seek a revenue increase in the future, and when they do, it's just going to be all that much higher, right? From the standpoint of they're going to have faced additional inflation, made additional investments, and one of the perhaps unintended consequences of the dynamics at play there is now the rating agencies on Friday actually announced they've put Pepco under review for downgrade as a result of withdrawing that case and the dynamics that are at play there. And so that's something we often talk about in these regulatory proceedings around it's important to have a healthy utility because that ultimately affects the rates at which we can borrow money, which ultimately flow through to our customers. And I think we're seeing a real example there of when there becomes concern about the environment the utility is in and the financial health of that utility, the rating agencies can and will take action to review that and potentially end up in a situation where those costs are impacting customers in a higher way.
So what happens from here? I mean, I know it may not seem like it right now, but at some point this hearing will be over. Once that resolves itself and we've moved on, of course the commission has to proceed with its lessons learned for our multi-year rate plan pilot. The General Assembly has directed us to conduct a study for fully forecasted test years. All of this is probably going to be resolving, or at least most of it will resolve before the end of this year. So here we are now with a historic test year case. There'll be some result for Pepco, which will probably result in some increase. What does the company see as the type of filing it'll make next time?
I think to your point, that all depends, right, on how things kind of play out over the coming year in terms of the commission study around forecasted test years. The legislature clearly has this in their purview in terms of, I know I heard from folks during legislative session about their views about how things could work that I'm sure will be talked about during this study. And so I think we need to continue to evaluate that process as things goes on. But I can tell you from where I sit today, I think the most effective form of rate making that we can move forward with in the state is one that looks at what we're doing as a utility and group of stakeholders ahead of time before we do it, understand the impacts it's going to have to customers, what the pace and sequencing of investment looks like in terms of those impacts, and what we can do to take affordability into consideration when approving rates going forward, as opposed to looking at things after actions have already been taken and things are set in stone. I think we get into a much more challenging situation to deal with affordability when you're looking at things in a rearview mirror as opposed to planning for the future. So, if we can get through lessons learned in that study and end up with a constructive forward-looking mechanism, whatever that might look like, I think we would enjoy the opportunity to, and I don't know when it would necessarily be, we would have to take, all of the broader factors, including, customers' needs and our needs into account. But I think we would prefer the next case to be of that variety so that we can make sure we've, got that conscious dialogue about what our plans ultimately mean for the state and our customers before we go off and execute.
Okay. All right, thank you. That's all I had, Mr. Chair.
Commissioner Suchman.
Good afternoon, Mr. Lemming.
Good afternoon.
So I wanted to talk to you about the White Flint substation, and you spoke about it in rejoinder, and I know that witness Allo is going to be going into the specifics, but I mostly wanted to talk to you about it at sort of a higher level, sort of a more of a 30,000 foot level. So my recollection is that the decision was made to begin to pursue this project around 2016. Am I correct in that? Okay.
Yes.
And then in the first MYP, the commission, you had asked the commission to pre-approve cost recovery for the substation. The commission said no, and then you paused the work. Is that correct?
Generally, I might say we didn't necessarily ask for pre-approval, but we shared our plans to do that substation in that
Okay.
filing.
I'm just reading from the commission order, so
Okay.
I'm assuming they got that part right. That you had asked for pre-approval. I wasn't on the commission, so but I'm assuming that's anyway. But that's actually so they said no, and then you stopped the work, or you didn't start the work.
I don't think the commission said no. I don't have the order in front of me.
Okay, the commission will not pre-approve Pepco recovery of future costs associated with the substation projects during the MRP.
Yes, and then
So I think that's what I'm reading from. So you'll have to trust me that this is from the commission order. So after that, you stopped. Did you stop the work, or did you not begin the work?
So I guess what I was going to try to clarify is we, when the commission issued that decision, I believe it had language to say that it did not tell the company to not continue with the substation, but it was not going to grant us contemporaneous recovery for those investments. And if we wanted to continue to pursue the substation, it would be in more of a traditional rate case fashion with recovery sought after the investment was made. And at that time, we got feedback from the commission's order that said you did not sufficiently, at least prove to us, that the load forecast, there were some questions about the accuracy of the load forecast at that
Right, but
time.
I'm mostly
And we went
interested
back.
in the postponement.
Yes.
So for about 2 years, you postponed from 2021 to about the end of 2023. Is that correct?
I don't know the exact timeframes of the
But
pause,
it's around.
but generally.
Okay. And do you have a sense of how much work was already done on the substation?
I do not. Company witness Alo would be able to speak to more of the specifics on that. I know we had certainly done engineering and design on the substation at that point. I don't know where it might have been in terms of construction at that point.
But for 2 years you stopped, and during that 2-year period, you hired Quanta Technology to do an analysis. Is that the sort of the general, or did you stop for a period of time and then decide that you should hire them? What were you doing during that 2-year period?
I'd have to defer to company witness Alo on that. I was not engaged in the evaluation of White Flint and whether or not to proceed with it on what time scale. That was done within the technical services organization. I do know to your point that we paused it, took an additional look at the load projections around it, and I think contracted with some external expertise to help validate that. But I'm not close enough to all the specifics in terms of timing of when those conversations and engagements happened and informed our path forward.
Okay, but when we're talking about the White Flint substation, we're talking about sort of the potential for big load coming on. There's the North Bethesda Gateway, there's expansion of Pike and Rose, there's the White Flint Mall that is just sitting vacant. But I'm assuming all of those potentials came into play when you made the decision to move forward with expansion of the White Flint substation.
Yes, I believe they did. Again, not my area of expertise, but I often heard in conversations and meetings about the conversations and expectations from developers that have been communicated to us about what was going on in that area and the need for capacity to serve that increase in load.
Okay. Was there any conversation with this potential load about them taking on the costs of of expanding the White Flint substation. I mean, we've had conversations over the last couple of years with large load in general, taking on responsibility for having to build out the system as opposed to socializing it. You're proposing in your application to socialize it so everybody's paying for this. Notwithstanding the fact that, I mean, I live in that area, so I know that area, and those are large potential load customers that are coming on. Was there a conversation within Pepco about assigning responsibility for build out to those customers when you knew the customers were going to come on? Because who knows when White Flint Mall is going to be built out?
Yep. I do not believe that was a consideration at that time. I'll ask if company witness Allo can correct me as I come up, but the conversations around large load impacts have been much more recent than I think that substation began, and that was not something that was considered as much at that time. I would also just note.
Yeah, but remember, I guess I would accept where you're going, where I think you're going, if you hadn't paused. But you paused for 2 years. Nothing was done for 2 years. And that pause was only 2 years ago. So it's not like we have just recently had these conversations about data centers. We've been having these conversations since I've been on the commission, and that's been 3 years. So, I'm asking this because we're talking about $189 million that are going to be paid by somebody. So you're asking that the ratepayers pay for it. And I'm asking if you have had conversations within Pepco about assigning those costs to the entities that are causing these increases in load.
I guess what I would offer is I'd say these are a little different than a data center to me in terms of it's not one single customer, right? This is a kind of economic development expansion of a region that's going to have many customers taking service here. So we're not dealing, in the case of a data center, with one entity where we might be able to structure things like a TSA where we can directly assign costs to them. But what I will say is we strive, and I think in our cost of service that company witness Schaefer can talk to look at the impacts that these types of customers have on the system and ensure that the costs they're causing are getting assigned to their class and they're paying the appropriate rates into that class to pay for their share of the cost of service impact that they have.
Okay, and would I be correct that if you were to have assigned the cost for building out the White Flint substation to these entities that were causing it, you would not be able to rate base that investment? So that would be a loss to the company.
Sorry, can you rephrase that?
Well, you have $189 million of build out of the White Flint substation. Had the $189 million been assigned to the various entities that are causing the build out, the North Bethesda Gateway, the White Flint Mall development, to the extent that that had been paid by those customers, you wouldn't be able to rate base that.
We could still rate base it if we would create a class that these costs would ultimately get assigned to, and then we could rate base it to that and assign it to that class so that they pay the rates directly to pay for all of the investment they cause. So I think in that case it would still be in rate base. It's just it wouldn't be maybe allocated to other classes. We could allocate it directly to that class of customers that might fall into that. That's one of the things that I know utilities and us are trying to look at from a data center perspective is can you have a data center class where those costs will get directly allocated to them, and then they stay in rate base, but that customer is responsible for them.
Okay, and have you considered doing that in this situation?
I do not believe that. We have just with, like I said, it's a little unique in terms of it's a wide range of customers from, to your point, mall, residential, commercial customers that make it a little bit more challenging. So I don't think we had looked at that previously.
Okay, that's all I have. Thank you.
Commissioner Hoover.
So you offered some comments on PECO's decision to pull their rate case. And obviously, since you filed your rate case, some of the factors affecting customers' ability to pay have been affected by situations literally beyond your control, based on actions by one of your customers in Washington, D.C. But I guess I'm trying to figure out, you're part of the process of determining that the company's going to file for a rate increase. I mean, you're not the sole decision maker, but you feed into that process, I assume.
Yes, I do.
And has there been any discussions within the chain of command at the company in reaction to what Pepco did and why they did it, as to whether or not Pepco should give a second thought about this application?
I'd say with respect to this application, we have kind of looked at where we are, and determined that we need to move forward with this case. As I mentioned with respect to Pepco, the rating agencies have now put them on review for downgrade, and there's a lot of things being evaluated there. We were in a different place to begin with than Pepco was when we filed in October of 2025. We had already put austerity measures in to hold back on hiring. We'd cut our capital investment portfolios. And from our perspective, are at a point where the funds from our operations, we're going to need to revisit things very likely. If we were to withdraw the application, we'd probably face similar actions from the rating agencies where they may put us on review to downgrade us. So we'd be looking at a situation where we could potentially be having to reduce our workforce, potentially revisit investment plans further, be looking at rating agencies downgrading us and our cost of debt going up. I think we look at all of those as negatively impactful to our customers in the long run. They might feel a little bit of relief here for the next 8 months or so. I can't speculate to if the case got pulled when we'd have to ultimately come back in. But the reality is we would need to come back in, and at that point, they would face that increase. It would likely be higher, and we would have had a lot more challenging service conditions for our company that would be impacting them in the more long term in terms of the level of distribution service quality that we could be providing to them. So I think as we look at all that in totality, have kind of assessed that notwithstanding that we do understand these things are impactful to customers, that we need to continue to move forward at this time.
Okay, thank you.
Commissioner McCain?
No part one questions.
I have only one very brief question that has to do with witnesses. During the course of questioning about issues like rates of return and earnings per share and other accounting related questions, I got the distinct impression that you felt that witness O'Donnell would be the most appropriate person to answer those kind of questions.
Yes, as our chief financial officer, she can certainly speak to the investor relations and capital allocation processes at Pepco.
Okay, I just wanted to make sure of that. Felt I heard that. Okay, so, oh, of course, yeah. No, what? What? No, I think we're good. All righty then. It is almost 10 minutes to 1, so we're going to break for lunch. We will come back at 10 minutes to 2, I suppose. So see you then. Lemming 2.0.
Part 2.
Good afternoon, Mr. Lemming.
Good afternoon.
Do you have before you the public version of Part 2 of your pre-filed direct testimony filed on behalf of Pepco in this matter, consisting of 50 pages and 2 exhibits?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
I do have a couple quick modifications. Schedule RTL3 that is attached to this, page 1. The first row where we cite plant closings of 68,974, that should be 113,850.
I'm sorry, Mr. Lemming, could you repeat that a little bit slower?
Certainly, sorry. The first row where it says 68,974, that number should be 113,850. This was corrected and discovered in rebuttal, but just for completeness, we'll fix here. The next row, 24229, that number should read 45136. And then the total should be 349601.
And, excuse me, Your Honor, may I ask a question? You said Lemming 2 public. Is this public direct?
Yes, this is public direct.
Thank you.
Yep.
Yes, the same schedule appears in my rebuttal testimony in a corrected fashion.
Okay. And with that correction, Mr. Lemming, if I ask you the same questions today, would your answers be the same or similar?
Yes, they would.
Your Honor, I'd like to have Mr. Lemming's the public version of Mr. Lemming's direct testimony marked for identification as Pepco Exhibit 5, I believe we're on.
So marked.
Thank you. Mr. Lemming, do you have before you the confidential version of Part 2 of your pre-filed direct testimony filed on behalf of Pepco in this matter, also consisting of 50 pages and 2 exhibits?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
The same corrections would be made to Schedule RTL3 in the confidential version as well.
Okay. And with that correction, if I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Okay, Your Honor, I'd like to have the confidential of Mr. Lemming's direct testimony marked for identification as 5C, if that works for you.
So marked.
Okay. And finally, Mr. Lemming, do you have before you your pre-filed rebuttal testimony filed on behalf of Pepco in this matter, consisting of 30 pages and 3 exhibits?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
And if I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Your Honor, I would ask to have Mr. Lemming's rebuttal testimony marked for identification as Pepco Exhibit 6.
So marked.
And at this time, Your Honor, I would like to move into evidence Pepco Exhibits 5, 5C, and 6.
Without objection, so moved. So entered.
Thank you very much, and the witness is available for cross-examination.
Thank you. Good afternoon, Mr. Lemming.
Good afternoon.
I think you might have just changed 2 numbers that I had some cross on, so bear with me. Let's start by turning to RTL-3, Part 2, which is attached to your direct testimony, and focus your attention on page 1 of 3. Okay. Am I correct that this page lists plant additions by internal tracking number, ITN, for the period from April 2024 through December 2024?
Yes, it does.
Okay. And during the course of my cross-examination, I'm going to refer to ITN numbers. I'm not going to refer to them as internal tracking numbers, okay? Now, on page 2 of Schedule RTL-3, you address projected plant additions for the 12 months of calendar year 2025, and on page 3 of 3, you present projected plant additions for the 12 months of calendar year 2026. Is that correct?
Yes, that's correct.
Okay. Can you point me to where in your filed direct testimony in this proceeding you explain why page 1 of 3 in Schedule RTL-3 only addresses the 9-month period from April 2024 through December 2024?
Just give me one moment. Just take a look at my testimony. Sorry, one second. I don't know that I have that in this testimony. In my part 1, I think I talk about the investments we've made since our last rate proceeding, so that would be my part 1 testimony. Our last rate proceeding covered the period March 31st.
Could you point me to that in your part 1?
On, I probably don't say it directly in the way I'm characterizing it here. So we talk about on page 6, line 11.
Wait, just let me get there.
Yep.
I'm reading those lines and I don't see where you address why you stopped.
Yep. So it says the company filed its last base rate case in 2023, and since then the company has made approximately $300 million in actual capital investments. So that that schedule reflects the actual capital investments we have here. Our last rate case proceeding had a test year that the commission authorized through March 31st of 2024, and so this case is now covering from that period of March 31st, 2024 and beyond.
But RTL-3, the first page, only addresses April 2024 through December of 2024, correct?
Yes, that's correct. The period through March 31st, 2024 was covered in case number 9702.
Okay, now, I'm going to hand out a packet of data responses, Your Honor.
Oh, yeah, sure. I'm sorry. I'm sorry. I want your step. Yeah, thank you. Oh, that's all right. Sorry.
Yeah,
Mr. Lemming, one of the exhibits in the packet that I just handed you. Is that better? Okay. Mr. Lemming, in the packet that I handed you, I'm not sure whether it's the first or the last document, you see a copy of page 1 of order number 91181 in case number 9702, dated June 10th, 2024. And you'll see there's a copy of page 59 and 60. Could you just read to yourself the last couple of lines of 59 and the first few lines of page 60? And I do have a full, complete copy of the order in the hearing room. Your Honor, I wasn't going to mark this as an exhibit unless you want me to, because it's just a quote from a commission order. Okay.
I don't think that's necessary.
Okay.
Yes, I've read that
Okay.
through, I stopped at the 69 kV feeder rebuild section.
Okay. Would you accept, Mr. Lemming, that in case 9702, the commission determined that it would set rates on the basis of plant in service at the end of March 2024 in that case?
Yes, I would agree with that.
Am I correct that at the time of the filing of your direct testimony in this proceeding, on October 14th, 2025, the plant additions for the 9 months ended December 2024, shown on page 1 of 3 in Schedule RTL 3, reflects the company's total plant additions for that period?
Yes, that's correct.
Now, I'd like you to also focus on the first 2 lines of data in RTL-3, page 1 of 3.
Sorry, you said page 1 of 3 in
Yes.
RTL 3? Yep.
Okay, on the first 2 lines of data on page 1 of 3 in Schedule RTL-3, we find entries for 2 White Flint projects, ITN 74120 and 74121. Is that correct?
That's correct.
Okay. For each of those 2 projects, we find a reference to witness Allo. Is that also correct?
That is correct.
Now, originally, before I think you might have just corrected 2 numbers, in RTL-3, page 1 of 3, ITNs 74120 and 74121 represent the 2 largest plant additions listed. And before you altered 2 numbers, together they accounted for over $93 million of plant additions for the 9-month period ending December 2024, correct?
That is correct.
Okay. And just to make sure that I have your numbers correct, that I wrote them down correctly, right now for ITN 74120, the White Flint Substation 6913 kV, I believe you said as of December 2024, that $68,000 number is now $113,890. Is that correct? Excuse me, $113,890,000. Is that correct?
850,000. And if it's easier, I'm happy to stay on this schedule too, but we have a clean version of it in my rebuttal as well, if that's easier to talk through.
Well, actually, I have all my notes on my version, so
Okay.
bear with me. Okay. And the number for the correct end-of-year plant additions for 2024 that you now altered that number, account ITN 74121 is now $45,136,000 Is that correct?
Yes, that's correct.
So now we're talking about close to $160 million of plant additions for the end of the year 2024.
Yes, that's correct.
Now, I would like you to turn to your rebuttal testimony filed on March 11th, 2026, and turn to the table on page 2, which lists the schedules attached to your rebuttal testimony.
I'm there.
Okay. For schedule, on that chart, somewhere between lines 5 and 6, for schedule RTL 2-R-3, the table on page 2 of your rebuttal testimony indicates schedule RTL 2-R-3 represents an update to schedule RTL-3 initially provided within your direct testimony. Is that what is represented?
Yes, that is correct. During discovery, before this was filed, we had received a question on that schedule and noted that those two values on the schedule were incorrect, and we provided an updated schedule to all parties with the updated numbers upon that discovery within the discovery process, and said we would include a corrected schedule and rebuttal and have attached it here as RTL 2-R-3.
Mr. Lemming, why didn't you provide an errata at the time that you found the error, an errata to your testimony?
I don't know the rationale for why not, as opposed to why we thought we had provided, an update to parties and served that upon them so that everyone could see it and made clear that there was a change to that schedule. I think we just, probably at the time, thought that was going to be an administratively efficient manner to update that and get it to parties, and did not necessarily think about filing an errata.
When you said you served the parties, it was in a corrected response to a data request. Do I have that correctly?
I don't recall, as I sit here today, if it was in a corrected response to a data request or in a data request itself.
Then specifically, how did you inform the parties?
In the response, provided an explanation of what we were providing and the fact that it had these 2 or 3 numbers that I just read in it that were changed and provided to parties.
So it was a response to a data request, correct?
Correct.
Okay. Do you consider a response to a data request the same thing as an errata to your testimony that's been filed with the commission?
I do not.
I'm sorry?
I do not.
Okay. Okay. Am I correct that the only changes to your initial schedule RTL-3 that are reflected in schedule RTL 2R-3 are the dollar amount shown for ITN 74120 and 74121 on page 1 of 3 of schedule RTL 2R3?
Yes, that's correct.
Now, the entry, I'm focused on 2R-3, the second of your rebuttal. Page 1 of 3.
You want me to go to the schedule?
Yes, please. Let's stay focused on RTL 2R-3. Okay. Now, the entry for ITN 74120, page 1 of 3 in RTL 2R-3 is $113,850,000. Would you agree?
Yes, I would.
Okay. And would you accept that represents an increase of nearly $45 million, or 65% increase, over the $68,974,000 that was presented on page 1 of 3 in your Schedule RTL-3 in your direct testimony?
Subject to check, yes.
Now, do I understand properly that your representation is that the $113,850,000 amount presented in Schedule RTL-2R-3 is the result of the company's correction of the application of an incorrect jurisdictional allocation factor for ITN 74120?
Yes, I believe that's how he characterized the update when we provided it.
Now, focusing on, I'm also on your rebuttal exhibit, now focusing on ITN 74121, am I correct that the dollar amount shown in Schedule RTL-2R-3, page 1 of 3, for plant additions for ITN 74121 for the 9-month period from April to December 2024 is $45,136,000?
Yes.
Would you accept that the $45,136,000 that you now show for ITN 74121 represents an increase of nearly $20,907,000, or an increase of 86% over the $24,229,000 that were shown on page 1 of 3 in your Schedule RTL-3?
Yes.
Do I understand properly that your representation is that the $45,136,000 amount presented in RTL-2 R-3 is the result of the company's application of an incorrect jurisdictional allocation factor for ITN 74121?
Yes, that is correct for the purpose of that number on this schedule. Yes.
Are the reasons you offer for this substantial change in the dollar amount reported for ITN 74121 the same as the reason for the change in the reported dollar amount for ITN 74120, that is, the application of an incorrect jurisdictional allocation factor?
Yes.
Am I correct that Pepco considers all ITN 74120 costs for the new White Flint substation to be 100% assignable to Maryland Distribution?
Yes, that is correct.
Do I understand correctly that some of the cost associated with ITN 74121 for new supply lines to the White Flint substation are considered sub-transmission costs that are partially allocable to other jurisdictions?
I would I would need to look at the underlying information for this ITN. It doesn't note that on here, but we need to.
I'm sorry, could you keep your voice up a little bit?
I would need to look at the underlying schedule here just to verify that that information is not captured on this schedule, and so I would just need to look at where that is to confirm that.
Okay. Or would you like to accept it subject to check?
Objection. I believe the witness just said that he would need to check. He doesn't know.
Sustain.
Please check.
Was that in a discovery response that we provided explaining that update?
There is something, yes, there is. Should I ask my question again? Am I correct that some of the cost associated with ITN 74121 for new supply lines to the White Flint substation are considered sub-transmission costs that are partially allocable to other jurisdictions?
I believe you've already sustained my objection, Your Honor.
Yes, I had.
Would you accept, subject to check, that significant portions of the cost associated with ITN 74121 are identified in your electronic-only attachment to AOBA Data Request 2-9 as sub-transmission costs?
Without looking at that and reviewing it, I can't confirm what's on that project or not. I would need the underlying details to look at.
Mr. Lemming, in your packet is the company's response to AOBA 2-9. Actually, there are. Look at the first one in your packet. It says, Potomac Electric Power Company, Maryland case number 9820, response to AOBA data request number 2, question 9, subparts A, B, C, D, E, F, and G. Your Honor, I would like to have this document marked as AOBA Exhibit 1.
So marked.
You had a minute to review your response?
Yes, I have.
Okay. Now I'm going to ask them the question again. Would you accept, subject to check, that significant portions of the cost associated with ITN 74121 are identified in your electronic-only attachment to AOBA 2-9D as sub-transmission costs?
Ms. Francis, I can't see this, so can you just identify for the witness where you're talking? I'm kind of looking through your document, and I'm not seeing sub-transmission.
If you take a look at the company's response to Part D on page, I guess it's, I don't know why it has page 16 on the bottom of it, but it says, Mr. Lemming, see, it says, see Maryland 9820 AOBA 2-9, attachment A, electronic only. In developing this response, the company identified an error in support for Schedule RTL-3, page 1, impacting the jurisdictional allocator applied to 74120 plant closings for this project, reflect distribution Maryland plant, and should be allocated to Maryland consistent with the allocation of other distribution Maryland plants. Now, that electronic attachment, I don't have that available now. Perhaps Mr. Lemming does, but that has several tabs to it. The next paragraph says, to be clear, this correction does not impact the company's FFTY revenue requirement. And it goes on to say this project was correctly reflected as distribution Maryland plant in the company's jurisdictional cost of service study. Do you see that?
Yes,
Okay.
I do.
Do you remember my question?
I believe if you're asking about what our costs on this ITN were sub-transmission, and my response here indicates that they are distribution Maryland costs, not sub-transmission.
My question had to do with ITN 74121. This first paragraph of the data response dealt with 74120. My question went to ITN 74121. Maybe this will help you, Mr. Lemming. Attached to your rebuttal testimony is a document that you've labeled Schedule RTL2, R-2, page 1 of 1. And it seems that you quoted the original response where you and I just read, and then there's you call it an updated response, and you have a new paragraph D.
Yes, I see that.
Okay. Your Honor, I was not going to mark this second document as an exhibit because it's Mr. Lemming's exhibit attached to his rebuttal testimony.
I have to say, I'm having trouble following. I'm not sure the witness is having trouble, but I'm having trouble.
Can I start over?
Please.
Okay. We did data request number 2. Data request 2, question 2-9. And there were parts A, B, C, D, E, F, and G in that question. And Mr. Lemming was the sponsor. I neglected to ask him, at the time you filed this response, were the answers true and correct to the best of your ability and knowledge?
Sorry, are you asking AOBA DR 2-9 were my answers true and correct to the best of my knowledge?
Included in this data request response, and also you have an attachment to that response, and you've labeled it AOBA DR 2-9G attachment, page 1 of 6. There's 6 pages there.
Yes, that's correct.
Okay. Subsequently to that, in your rebuttal testimony, Mr. Lemming, did you update your response to Part D of 2-9? Commissioner Suchman, does you follow that?
Yeah, if you could help the witness to just identify the page where he made that statement.
Okay, Your Honor, the problem is the revised response is included in his rebuttal testimony. We asked a data request, I got a response. Later on in his rebuttal testimony, he attached his response, his updated response, his revised response, whatever you want to call it, he put it in his exhibit. So it's his exhibit attached to his rebuttal testimony.
Right, but I'm trying to figure out where that is. So he may know, but I don't know.
Okay, it's in I found it in his rebuttal testimony where his schedules are, because it's marked Schedule RTL, Roman numeral 2, -R-2, page 1 of 1. It's in his testimony. Mr. Lemming, can you help Commissioner Suchman out with that? That's where I found it.
Part 2 of my
What?
Okay, you know where it is.
my rebuttal testimony,
Okay.
Part 2.
Page 17.
It's the first schedule I have attached, and yes,
Page 17 of 18. Try that in the PDF.
I'm looking at Part 2, rebuttal. Okay, you continue on. I'll figure it out.
Well, it was complicated for us because it was attached to it was an update to our request that somehow got into his rebuttal testimony.
Do the two of you know where We are. Because theoretically, you should be able to answer the question.
I know. Well, I think I know where we are, but I'm not sure what the question is.
If you could repeat the question.
Yes, I will. Do you know, I'm going to ask Mr. Lemming to go to his rebuttal exhibit.
I'm there.
Okay. Would you accept, subject to check, that significant portions of the cost associated with ITN 74121 are identified in your electronic-only attachment to AOBA Data Request 2-9D as subtransmission costs?
No, I would not. The response that you pointed me to here indicates that these are Distribution Maryland costs. They're not subtransmission, and that is why we provided this updated schedule. We had them allocated originally in the schedule, not in our cost of service, but in that schedule as subtransmission costs. Realized that they were actually direct distribution costs, and we updated that, provided it to parties, and then I attached this DR to my rebuttal to make it clear that we had discovered this, and we were updating to try to get that correct number into the schedule for parties to use in their recommendations throughout the proceeding.
Okay. Now, can you point to where in the company's testimony and schedules in this proceeding the separate allocations of subtransmission and distribution components of costs for ITN 74121 are documented?
They are in the jurisdictional cost of service study that is attached to company witness Nelson's testimony. It used to be, I used to have one in mine as well, but that was part of the forecasted test year request that we withdrew from this proceeding.
Okay. Now, am I correct that the revised dollar amounts for ITN 74120 that is presented on page 1 of 3 in Schedule 2R3 represents the company's correction of a computational error?
That is correct.
Okay. And I believe, I don't want to go over something that I've already done, but you suggested that the company did not file an errata to your direct testimony because you informed the parties through a response to AOBA Data Request 2-9. Is that correct?
Yes, since it didn't change the overall revenue requirement, it was a presentation issue on a schedule. I think that was probably part of the thinking that we had updated that and would get it corrected in rebuttal for parties.
Now, just to make sure I cover this, Mr. Lemming, you are the sponsor of both the company's response to AOBA Data Request 2-9, parts A, B, C, D, E, F, and G, as well as the updated response contained in the company's RTL 2R-2, correct?
Correct.
Okay. And are both of those responses true and correct to the best of your knowledge and belief?
Yes, taking into account that we updated the response to D in between the two as we continued to prepare the schedule. Noticed it was that second ITM and was impacted as well and updated that. So if you apply that change to the first one, they would both be accurate.
Just to make sure the record is as clear as I can make it, the updated response to Part D presented in the rebuttal testimony RTL 2R-2 comprises 2 paragraphs. Am I correct that the first paragraph indicates the company identified an error in its support for Schedule RTL-3, page 1?
They didn't update this one.
That's correct. That's what it says.
Okay. Now, in the second paragraph of the company's updated response to AOBA Data Request 2-9 Part D, you stated, these projects, ITN 74120 and 74121, were correctly reflected as distribution plant in the company's jurisdictional cost of service study and revenue requirement.
That's correct.
Now, at the time that you wrote that response, were you referring to, let me ask it this way. Can you point the commission to the jurisdictional cost of service study to which you refer in your response to AOBA DR 2-9 Part D?
I no longer can, as this is all referring to the jurisdictional cost of service study that related to the forecasted test year, which we have withdrawn from this proceeding.
Okay. Now, am I correct that at this time, the only JCOS analysis remaining in the record of this proceeding are those presented by witness Nelson in Schedule CN-2 and CN-S-2?
Subject to check, I'd say yes, he sponsors the jurisdictional cost of service study. I don't know what the numbers of those exhibits are.
So, are you saying that at this time you cannot state whether the projects for ITN 74120 and 74121 were correctly reflected in witness Nelson's sponsored JCOS Schedule CN-2 and CN-S-2? SD-2.
Objection, Your Honor. I think that is a question for witness Nelson, not this witness.
Well, Your Honor, this witness says we asked him a data request, and he said the projects, in his updated response, the projects were correctly reflected as distribution Maryland plant in the company's jurisdictional cost of service study and revenue requirement. So he's the one who brought it up, and now I'm asking him, and that was his updated response.
I'll let it go, overruled in this case.
I believe it's fair to say the number is correct in both my and witness Nelson's jurisdictional cost of service study. We relied on the company's same general ledger to produce both of our cost of service studies. So I would fully expect that the same results coming from the ledger are in both of our studies, and that number is accurately presented on our ledger.
So you would fully expect that to be true, but you don't know that to be true. Is that correct?
I mean, as far as I can know something to be true, I believe that is true.
Would you accept that there is nothing in the detail of either Schedule CN-2 or Schedule CN-SD-2 that details the jurisdictional allocation of plant by ITN?
Objection, Your Honor. Now Counsel for Ioba is asking this witness about schedules that are not even in his testimony.
Your Honor, I can, of course, and will ask witness Nelson, but this witness is the one who testified in an updated response attached to his updated testimony that it was done correctly. So if he's saying it's done correctly, he should be able to answer a question about it.
And Your Honor, that was before we withdrew the forward-looking test year, as the witness has already testified, and this information is already available in witness Nelson's testimony.
Sustained.
Now, could you please, we're still focused on 2-9F, and that's what AOBA just had marked for identification as AOBA Exhibit 1. In Part F of ALBA Data Request 2-9, the company is, quote, asked to provide the data analyses, work papers, and assumptions the witness has relied upon to verify that CIAC amounts assessed of Pepco's Maryland customers for each ITN have been eliminated from all plant additions, end quote. Am I correct that your response to Part F, of ALBA Data Request 2-9 indicates no such analyses have been performed?
Yes, that's correct. I did not perform any specific analyses to verify that. I leveraged our company's accounting records, which are independently audited, are subject to accounting controls to ensure accuracy around application of payments such as this. They go through an independent audit process overseen by PwC, our independent auditor, and we were issued clean audit reports that there were no material misstatements for that period in time. So that was what I rely on to ensure that our general ledger is accurate for purposes of rate making. I did not perform a specific analysis with work papers or assumptions.
Now, however, your response to Part F of ALBA Data Request 2-9 indicates it goes on to refer the reader to the company's response to ALBA Data Request 2-12. Is that correct?
That is correct.
Okay. Now, in your packet that I handed out a little while ago, there is a copy of the company's response to 2-12, which, Your Honor, I would like to have marked as ALBA Exhibit 2.
So marked.
And Mr. Lemon, could you see that you're the sponsor of ALBA Exhibit 2, a copy of Pepco's response to ALBA Data Request 2-12?
Yes, I'm the sponsor of this.
Now, is the company's response to ALBA Data Request 2-12 true and correct to the best of your information, knowledge, and belief?
I'm just going to take a moment to review it really quickly. Okay, I've reviewed it, and yes, it is true and accurate to the best of my knowledge.
Okay. Am I correct that your response to ALBA Data Request 2-12 provides no work papers, data, or analyses that demonstrate the reasonableness and appropriateness of Pepco's tracking and reporting of CIAC receipts and the application of those receipts in the reporting of project costs for inclusion in rate base?
No, I believe we discuss our accrual-based accounting methodologies, and as I noted earlier, as we maintain our accounting records in compliance with generally accepted accounting principles, I rely on that fact, and then the independent audit that all this information goes through to rely on its validity for use. There is no independent analyses I have done as requested here.
Okay, so there's no independent tracking and reporting of CIAC receipts and the application of those receipts in the reporting of project costs.
I'm not sure that's what I said. Can you repeat the question one more time, please?
Okay. Am I correct that your response to ALBA Data Request 2-12 provides no work papers, data, or analyses that demonstrates the reasonableness and appropriateness of, very specifically, Pepco's tracking and reporting of CIAC receipts and the application of those receipts in the reporting of project costs for the inclusion in rate base?
No, I believe to that question my answer was we follow generally accepted accounting principles, and that's what I rely on, is that in our independent audit we go through to verify the accuracy and validity of those records. I do not perform additional validations with work papers and assumptions myself.
And in those procedures, there is no specific that you're referring to. There is no specific tracking by reporting the CIAC receipts and the application of those receipts to a specific project, correct?
I can't speak to the procedures that our accounting department and PwC go through to test the validity of these controls.
So if you're relying on the accounting procedures, you don't know whether the answer to, you don't really know what the answer to my question is, correct?
Objection, Your Honor. It's been asked and answered.
Yeah, I believe so. Sustained.
Does anything in your response to data request 2-12 provide a quantitative assessment of the time lags between the company's receipt of CIAC contributions from customers and when the costs for the related projects to which the CIAC contributions purportedly applied are actually incurred?
No, and I don't believe the question asked for that. It asked for us to, whether there's explicit recognition that there is typically lags, and I believe we do note that we do bill in advance. It did not ask for any sort of quantitative analysis about that difference in time that may exist.
Well, the question does say, please document Pepco's tracking of its receipts of CIAC. And you do not have an independent analysis of the tracking of those receipts, as I deduce from your answer to my previous question, correct?
Yes, I did not perform an independent analysis of that.
Okay. Now, also in your packet is Pepco's response to AOBA data request 2-7. I'd like to have that marked as AOBA Exhibit 3.
So marked.
Okay. Do you have that, Mr. Lemming?
Yes, I do.
Are you the sponsor of the company's data request 2-7 response?
That's what it says.
Yes, I am.
Okay. Is the company's response to AOBA data request 2-7 true and correct to the best of your information, knowledge, and belief?
Yes, it is to the best of my knowledge.
Now, there is an attachment to that response. So please look at the attachment to your response to AOBA data request 2-7. Am I correct that the numerical entries listed by ITN under the heading FERC 107000 and FERC FERC 108100 and total all represent dollar amounts?
Yes, that's correct.
Would you explain for the record what the negative and positive entries in the 3 right-hand columns of the attachment to Pepco's response to AOBA data request 2-7 represent?
Certainly, these reflect the accounting entries as asked. AOBA asked us to document the total kayak that was received by Pepco during the 12-month period ended December 31st, 2024 by jurisdiction, by FERC account, and by ITN numbers. So we have 3 tables that I'm looking here that provide this by or I guess it's one table that lists out the jurisdiction as a column, the ITN as a column, and the FERC account as a column. So these are all the accounting records we have with respect to kayak activity that occurred within these, without having the benefit of all the ledger details behind this. I can't say what each specific charge is for, but generally I'd say the negative activity is an application of a kayak payment, and then where we have unitization and closing of projects, you have entries from an accounting perspective that will move across FERC accounts, and those reclasses can be captured as a positive amount in certain FERC accounts as that's occurring.
I think, Mr. Lemming, my question is meant to be a little simpler. negative entries, are those receipts of funds? Is that what the negative entries are?
It can be a receipt or a potentially a reclassification between accounts, but generally most of them should be receipts.
Okay, and the positive amounts, are those the outflow of funds?
I don't know. I'd have to look through all the records. Those could be, like I said, reclasses of cost counts and accounts and accounting entries that happen as we move projects through construction.
Because it's difficult to figure out what you're classifying as a receipt and what's negative and what the positive is. So the negative entries are receipts or reclassification of funds, and the positive amounts are you're not sure, correct?
They are either the receipts or reclassifications of funds.
Okay. Well, wait, I thought you said the negative amounts are receipts or reclassification. What specifically are the positive amounts?
This is all the accounting activity that occurs with respect to our kayak costs as requested by AOBA here, and so these are the accounting entries that support the activity behind that, and so this reflects the debit and credit activity of how our kayak funds are received and applied to the FERC accounts as AOBA requested.
No, I understand that, but I don't know why you have some negative and some positive. What are the positive amounts, the outflow of funds, or is it something else?
It could be an outflow of a fund. It could be a reclassification across projects or accounts. It would depend on the entry itself that underlies all of this.
Okay. Can you explain the circumstances under which a positive entry for CIAC would be recorded?
If there was any reason that, as we just discussed, it was returned to a customer for any reason, or if it was included on an ITN here, but was later that ITN could have been broken apart into different projects, and that could have been applied to another project, you would debit it off one project and credit it to the other, and so that debit could be showing up as a positive activity, and the negative would be the credit to the other project. So there's probably tens of thousands, if not more, of entries that underlie all of this data that capture that activity that occurs from an accounting perspective.
Okay. Now, am I correct that where Maryland is under the heading jurisdiction, the dollar amount shown for CIAC entries for Pepco's Maryland service territory, is that correct?
Yes, where it says Maryland in the jurisdiction, these are kayak payments for projects with a Maryland classification.
Does the Maryland total near the bottom of page 2 of 2 in the attachment to your response to AOBA data request 2-7 indicate that for the 12 months ended December 31st, 2024, Pepco receives CIAC contributions that total to over $19.9 million?
Yes, that's correct.
Okay. Would you accept, subject to check, that witness Nelson's exhibit CNSR-1 shows an unadjusted dollar amount for cash working capital of $11,025,000?
Objection, Your Honor. That's a question for witness Nelson.
Yeah, I think you're correct. Sustained.
Okay.
Before we go too much farther, forgive me for I'm probably violating our procedures by asking this question, but could I just ask a very simple question about this chart? Are the bracketed numbers credits and the unbracketed numbers debits? Is that how you got these? Because typically in accounting, the bracketed numbers are credits and the unbracketed are debits.
I believe that's correct, yes.
Okay, thank you.
I was sorry, mess up which side of my ledger I'm on.
Your Honor, I'm glad you asked that question, but that was a different response than I got to my question. And I was kind of asking the same thing. What he said, as far as to me, was he didn't know that some of them are reclassifications. So you kind of got a clear answer, which is what I was trying to get, but
Well, no, you were asking if they were receipts, and I couldn't figure out what a receipt is in the context of the, anyway, you've answered my question.
now I'm going to ask you to go to 2-9. Your response to part G. This is what was marked as ALBA Exhibit 1. Do you have that?
Yes, 2-9-G.
Okay. Just to be clear, Your Honor, I'm looking to the attachment to ALBA Data Request 2-9, and I'm now focusing on Part G, which is attached to that response. It's 6 pages. Am I correct? Are you with me, Mr. Lemming?
Yes.
Okay. Am I correct that there are often costs incurred during a given calendar period for the ITN that are not placed into service during the same calendar period?
Yes, that's correct.
Am I correct that some long lead time projects may have more than 1 year between the incurrence of initial costs and the time the plant for which those costs were incurred is placed into service?
Yes, that's correct.
Do I understand that Part G of AOBA Data Request 2-9 is intended to focus on those costs that have been accrued for a given ITN but have not been placed into service and are therefore carried forward for possible inclusion in plant in service in a future period?
That is my understanding of what I believe AOBA is asking in this question, and their question specifically relates to the projects that were in 2024 on the schedule.
Now, please take a look at the attachment to the response to 2-9 Part G. The first 3 pages of that attachment list descriptions of ITNs. Am I correct that the dollar amounts for plant costs carried forward for the listed ITNs are found on pages 4 through 6 of that attachment?
Yes, yes, that is what is included here.
Okay.
Counsel, just so I'm clear, is this supposed to be read across as if it's like a landscape? Just so
That's what I'm trying.
correctly-
That's what I'm trying to figure out.
Okay,
Okay.
I'll let you ask.
Good question.
Yes, that's exactly what it is. So you have to get out your pen, tape and put these.
Get my ruler out and.
That's
gotcha.
right.
Okay.
Okay.
Yeah, because this last line is one less than.
Do you remember my question, Mr. Lemming?
Sorry, I thought I answered the last question. What was the question?
The first 3 pages of that attachment list descriptions of ITNs. Am I correct that the dollar amounts for plant costs carried forward for the listed ITNs are found on pages 4 through 6 of that
I think
attachment?
it's the white
Yes, that's correct.
Okay.
substation.
Is there a reason that the data in this attachment could not have been formatted in a manner that the ITN description and dollar amounts for 2024, 2025, and 2026 were presented in a single page?
I think it might have been challenging to fit it all on a single page, but I do think the spirit of your question, we probably could have formatted this better, and I do apologize for, I don't know that when this was put together, it was viewed as printed, and we can certainly do a better job with that.
But I mean,
Okay, can I just, I'm going to step in because the chair already stepped in. That,
my fault. Huh?
yes, it's all his fault. So page 4 of 6, is that 0, that first 0, does that correlate to White Flint new substation? Or does it start with the 44?
In other words, 74,120.
Right, I can't figure out where it starts.
Yes, that should start at 74,120.
What should start at 74, 120?
The 0.
Yeah.
That first 0 that you saw on the chart.
Is for 74,120. Okay.
I was getting to that. It's okay. Thank you. So if we line up the dollar amounts listed on pages 4, 5, and 6 with the ITN numbers listed on pages 1 through 3, we can get what the numbers are for, and I'm interested in the first two ITNs, 74120 and 74121 on page 1 of 6. Now, if we turned, so please look at that. Now, if we turn to page 4 of 6, am I correct that we find ending balance for ITN 74120 and 74121 for 2024 of $0 for ITN 74120 and $44,496,000 for ITN 74121. Is that correct?
Yes, that's correct.
Based on the 2024 ending balance for ITN 74120, would I be correct to conclude that all costs for ITN prior to the end of 2024 were placed into service on or before December 31st, 2024?
Yes.
Now, turning our focus to ITN 74121, does the reported 2024 ending balance of $44,496,000 for that ITN indicate that there were $44,496,000 of cost for ITN 74121 that were not placed into service on or before December 31st, 2024?
Correct.
Now, I would like to go back to your rebuttal schedule, RTL 2 R-3, page 1 of 3, for plant additions for ITN 74121 for the 9-month period from April to December 2024, which we discussed earlier was $45,136,000, correct?
Correct.
And that was from the 9-month period from April 2024 to December 2024, correct?
Correct.
Is it your testimony that Pepco realized $45,136,000 of plant additions for ITN 74121 and still had another $44,496,000 of plant additions to be realized in calendar year 2025, thereby reflecting total expected plant additions for ITN 74121 of nearly $90 million?
Yes, I would defer to company witness Allo in terms of when those were all expected to go into service and if there were any ongoing activities, but yes, those two numbers add up to that amount.
Okay. You, in your schedules, your rebuttal schedule, as well as the direct schedule, RTL R-3 and RTL 2-3, you have various references to various witnesses. Allo appears quite often, Williams, Vosvik, O'Donnell. Do you see that?
Yes, I do.
Okay, now you also just mentioned witness Allo. And would you accept that witness Allo's schedule in his direct testimony, page 14 of 88, reports only 9,356,000 of actual 2024 plant additions for ITN 74121, budgeted plant additions for ITN 74121 of $13,116,000 and no budgeted plant additions for that ITN in 2026.
Objection, Your Honor. That's a question for witness Allo, not this witness.
Your Honor, the problem that I'm having is that these witnesses all refer to each other. They all give numbers, various numbers, and I'm focused right now on the White Flint. And the numbers are substantially different between witness Lemming and witness Allo. So I can always, of course, ask the same questions to witness Allo, but I can't really pin anyone down on an explanation of why we are talking for enormous differences in the dollars coming from witness Lemming and not coming from witness Allo.
In this case, I'll overrule it, allow you to continue asking.
Okay.
Do you have perhaps a copy of his exhibits or schedules you're referring to that I could
Yes,
just
I-
look at to make sure I understand what numbers you're
I
pulling?
do. Let me try to remember where I put it. Okay. Can you pull it up so I can share with you? Okay, thank you.
Yeah.
Your Honor, I'm just so you can, the commission can follow along. I'm referring to witness Allo's schedule, TOA-1. Right now, I'm referring to page 14 of 88. And I'm going to hand the witness a copy of that page.
Ms. Francis, is that direct or rebuttal, ma'am?
This is direct.
Thank you.
You're gonna provide us a copy also?
I don't have, I didn't make copies of the company's testimony. I have my copy I can show to the witness if
No,
Pepco doesn't have
No,
it.
no, Ben,
No,
he's gonna make a copy so we can follow along.
Okay, thank you. Do you want to have my copy? I've got notes on it.
Yeah, let's, well, before we take a 5-minute break, I'd like to make a bench request. The attachment DR29G that you have on these pages, could you put that into an Excel spreadsheet and transmit it to everybody so that we can follow the numbers?
Yeah, and we'd be happy to clean up the formatting too and make this much more
Right.
readable. I don't know if this will help expedite things, but I saw the page you were holding up and think I might be able to explain quickly why these are different numbers we're talking about across our schedules, if that's helpful.
Well, can you also, because now we're having, it's like whack-a-mole, and if you can explain also why these numbers are different than the numbers in your testimony, because we're coming back to your testimony in the rebuttal. So this is page
14 of 88 of TOA-1.
Thank you. So because we've got, for the two different ITN numbers coming into plan additions for 2024, 113 million and 45 million. So we've got numbers that are very different, and I'm having trouble following them. But I'm assuming you're in a much better position to explain why the numbers are so different. And why don't we do that after the break? If you
Right.
wanna-
Well, the break was to get a copy of the document.
Oh, okay.
Well, go ahead and get a copy of the document. We'll take a break for 5 minutes. And we're back. Where were we?
Shall I repeat my question?
Please.
Okay. All right. Okay, I think the question I just finished up, Mr. Lemming, we established that there were a total of approximately $90 million established for ITN 74121. If we added the $45 million to the $44 million, that was what was reflected for ITN 74121, correct?
That's correct.
Okay. Now, would you accept that witness Allo's schedule TOA-1, page 14 of 88, reports only $9,356,000 of actual 2024 plant additions for ITN 74121, budgeted 2025 plant additions for ITN 74121 of $13,116,000, and no budgeted plant additions for that ITN in 2026. Is that what's reflected on page 14 of 88 of witness Allo's testimony?
No, it is not.
Okay. Then could you please clarify that for me?
What is reflected in witness Allo's testimony, and this is an exhibit that's consistent with documents that every utility that's been filing multi-year plans or forecasted test years to date has included in their exhibits. These are forecasts of capital expenditures that the company will be making over the coming years. These are not necessarily the dollars that are being sought for recovery and being added to plant and service in a specific year. So as we've kind of evolved through this process, if you will, and in some of Pepco's past cases we talked about, we really need clarity on, in a forecasted test year, what is going to go into service each year so we know kind of what we're reviewing. And I had provided that schedule in my testimony to try to show by year of all the money we're spending, what are we placing into service each year that we're ultimately asking for recovery of in this proceeding. Although I note now at this point, a lot of that has become irrelevant as we are now talking about the costs of service that is included in company witnesses' traditional test year case at this point.
Okay, except when I look at TOA-1, page 14 of 88, the 2024 number is an actual number, correct?
A capital expenditure number, not a plant closing number. Those are two
Okay, but
different.
it is an actual number. It's not forecasted, correct?
Yes, that is an amount of actual CapEx that we spent on that ITN in 2024.
Okay, and the $13,116,000, that is a budgeted number, correct?
That's correct.
Okay. And the $0 for 2026, that is also a budgeted number, correct?
That is correct.
Okay. How do you reconcile the information for ITN 74121 in your schedule RTL 2-R3, page 1 of 3, with the actual and budgeted numbers in witness Allo's schedule TOA-1, page 14 of 88?
I don't try to reconcile them in my testimony. Again, my testimony includes all the numbers that we were planning to transfer into plant and service. So most of these in 2024, all of these, were dollars that went into plant and service, into rate base to be sought for recovery and rate base. And then the following schedules, we're looking at what we were projecting to put into rate base for those periods. No longer relevant here since we're not asking for anything on a projected basis with respect to plant closings. But those represented White Flint, right? We started this project 10 years ago. This represents all the money that had been kind of spent over the course of that 10-year period. What was going into service in the specific rate years in this proceeding. So that is one view of accounting information around plant additions. These numbers on these schedules are capital expenditures. So these are the additional funds on a going forward basis that we would plan to spend as a business to complete these projects. They do not reflect all the past expenditures that had already occurred.
Now, I'm going to switch to a different subject for a moment, and I'm going to ask you to please reference page 17 of your rebuttal testimony.
I'm there.
You have to give me a minute, please. Starts on line 19. That's right. Mr. Leving, please reference page 17 of your rebuttal testimony and focus of the discussion on line 19. In that discussion, on page 17, line 19, you present your characterization of AOBA witness Bruce Oliver's position regarding the company's recovery of current rate case cost, or RMA 5. Can you point me to where you rebut his position?
I'm sorry, can you restate the question?
Okay, page 17, line 19.
Yes.
Starts with no, as the preliminary matter, the company has provided invoices. That's, just please take a look at those few lines.
Yes, I see them.
Okay. Can you point me to where you rebut Mr. Oliver's position?
I mean, I think it says, do you agree with his recommended rate case cost disallowance? And I'm saying, no, I do not agree with it, and I provide a rationale for reasons that, they reflect a fulsome and reasonable estimate of the cost to prepare and litigate this proceeding, and that we've got executed contracts with vendors informed by actual incurred costs. So this is my rebuttal of his position to disallow those costs.
Okay. But in fact, aren't you merely summarizing what you believe Mr. Oliver said rather than rebutting what he said?
Pardon me, I didn't hear what your question was. If you could repeat that.
Okay, yes,
Closer
certainly.
to the microphone.
In the discussion that starts on page 17, line 19 of your rebuttal testimony, you present your characterization of AOBA witness Oliver's position regarding the company's recovery of current rate case cost, RMA 5. Can you point me to where you rebut his position? My follow-up question to that was, aren't you really summarizing your understanding of Mr. Oliver's position rather than rebutting it?
I think what I'm doing here is offering my position. The question is, do you agree with his position? I actually don't know that I really summarize his position fully. I say that, no, I don't agree with his proposed disallowance, and I offer the reasons for why I do not agree with that disallowance.
18, 17, okay. The company has now withdrawn its advocacy of rates based on a fully forecasted test year. Is it the company's position that it should be compensated for current rate case costs associated with its development and presentation of support for its fully forecasted test year?
I'd say the company is requesting recovery for the cost that is incurred to litigate this proceeding here.
Okay. Now, what evidence has the company provided to support the benefits that its Maryland ratepayers will derive from the company's development and presentation of its fully forecasted test year proposal?
I'm sorry, can you repeat that question one more time?
What evidence has the company provided to support the benefits that its Maryland ratepayers will derive from the company's development and presentation of its fully forecasted test year proposal?
I'd say the thousands of pages within this docket represent that evidence. My Part 1 testimony speaks to the overall benefits of what we're looking to provide to customers in terms of support for state policy goals, our reliability of our service that we offer for customers, the assistance we look to offer them, et cetera. That was all in the Part 1 testimony that I had this morning that we kind of talked about. And then each of our operational witnesses and witnesses to follow all touch on the benefits that our work and service provides to the customers we serve. So this whole case kind of supports the benefits it provides, and this is the cost I've put on that case.
Okay. Now, looking at page 17, line 21 of your rebuttal testimony, you state that AOBA witness B. Oliver recommends that rate case costs should only be recoverable in proportion to the percent of the company's requested revenue requirement ultimately approved.
Sorry,
Am I correct?
Can you point me to where you are?
I am on line 21 on page 17.
Of my rebuttal?
Yes.
I do not have that same reference.
I don't either.
Okay. I'm looking at the last line, and I'm reading on page 17. I'm going to read on line 21. He recommends, Mr. Oliver, that the Commission deny recovery of Pepco's rate case cost estimates, and that generally rate case costs should only be recoverable in proportion to the percent of the company's requested revenue requirement ultimately approved by the Commission. Do you see that?
I think you're looking at page 15, Counsel.
No, I'm looking at page 18.
I see the same reference Miss Francis does. I'm looking at what was filed, redlined on Friday night, page 17, rebuttal.
I stand corrected.
I'm looking at it right now. Same. I'm looking at what you just read.
On page 17, line 21.
I downloaded this from the Commission's docket.
Your Honor, in the version that the witness has, I believe that language does appear on page 15, but
Okay.
Ms. Francis' reading of it does appear to be accurate.
Does appear?
It does appear to be
Okay,
accurate.
right.
I'll let the witness confirm. On the version that the witness has, yes, the
Page
page
15.
15.
Okay. All right. We'll give him a chance to get there.
Okay, now I'm on page, it's on lines 5 through 8 of page 15 on my testimony for some reason.
Do you need me to ask the question again, Mr. Lemon?
If you could just give me one moment to read it, and then, okay, I've read that.
Okay.
Can you repeat
And
the question,
my
please?
focus of the question is where you state that AOBA witness is recommending that rate case costs should only be recoverable in proportion to the percent of the company's requested revenue requirement ultimately approved. That is how you characterized his testimony, correct?
That is correct.
Okay. Now, what you are characterizing is what you've taken from AOBA witness Bruce Oliver's position in his direct testimony at page 82, lines 11 through 15. And I will read it to you if you don't have a copy of it. The Commission should discourage Pepco's incurrence of large rate case costs at ratepayer expense by establishing a policy that relates the company's recovery of directly incurred rate case cost to the percentage of the company's overall revenue increased request that the company ultimately deems reasonable and appropriate. Did you see that?
I don't have his
Oh,
testimony in front of me.
do you understand that? Is that what you were responding to?
Yes, in part.
Okay. Would you accept that a more accurate statement of witness Bruce Oliver's recommendation is that the company's rate case cost be reduced in proportion to the percentage of the company's overall revenue increase request that is ultimately approved?
Your Honor, objection. I don't think this witness should be speculating on what witness Oliver meant. I believe that Mr. Lemming, he took his best shot in his testimony.
Your Honor, it's our position that in his testimony, Mr. Lemming completely mischaracterized what Mr. Oliver was focused on. Mr. Lemming's characterization focuses on the fact that he believes Mr. Oliver was recommending a percent of the total revenue requirement, when actually what Mr. Oliver was recommending was talking about the incremental revenue requirement. Those are very, very different calculations.
I would note, Your Honor, that Mr. Oliver had the opportunity to address this in sur-rebuttal.
Yeah. Okay. I'm going to sustain your objection.
Okay.
Well, we still.
Do you understand the difference between the company's suggested requested revenue requirement and witness Oliver's language that references the company's revenue increase request? Are those two things different in your mind?
Let me restate this. What I understand, the first thing, the company's revenue requirement, I understand that to be the amount that we were seeking in this proceeding, the amount of incremental revenues that we're asking for in our revenue requirement in this proceeding. Do I understand it to be different than the incremental revenue increase?
Well, I think what I just heard you say, that you believe that they're the same. In other words, if Mr. Oliver is suggesting that if the company, let's just say the company requested a $100 million increase, and, for example, the commission grants Pepco a $50 million revenue increase, the company would have been granted 50% of its request. And do you understand what Mr. Oliver is recommending? That if the company spent $20 million on rate case costs, they would recover 50% of that, or $10 million. Is that how you understand Mr. Oliver's testimony?
Yes, and that's what my testimony says here, that he suggests it should only be recoverable in proportion to the percent of the company's requested revenue requirement ultimately approved by the commission.
The company's requested revenue requirement, you're not suggesting that's the total amount of revenue requirement. That could be $600 million, $700 million.
No, I'm referring to the revenue requirement of $128 million that's on my front page of my testimony.
That's fine. Thank you, Mr. Lemming. Thank you. Now, I'm just going to pass out one more data request response. Mr. Lemming, I'm going to give you a copy of a response to ALBA data request question 4-24, and there are two witnesses listed on this response. One is witness Williams, and the other is witness Lemming.
Oh, sure, sure. Ouch.
Your Honor, I would like to have the company's response to AOBA data request 4-24 marked as AOBA Exhibit 4.
So marked.
And you can see, Mr. Lemon, you are one of the sponsors of that exhibit.
Yes, I am.
Okay. Now, is this requesting information regarding ITN 189803?
Yes, that is what it says.
Does the second paragraph of the company's response to AOBA data request set 4, question 24, recognize that cost for ITN 189803 were inadvertently excluded from Schedule RTL 3?
Yes, for the forecast period 25 and 26, that's correct.
Does the second paragraph of the company's response to AOBA data request set 4, question 24, also indicate that the identified exclusion would be remedied in rebuttal testimony?
Yes, it does, and then we've subsequently withdrawn that.
Okay. Now, I would like you once again to reference your rebuttal schedule RTL 2R-3. Do you have that?
Yes, I'm there.
Okay. Would you accept that there is no reference to ITN 189803 in your rebuttal schedule RTL 2-R?
Yes, that's correct. I do not see it on here.
Okay. Again, Mr. Lemon, can you tell me why didn't you provide an errata for schedule RTL 3 when you identified the problem in December of 2025?
I believe as noted here, the closings were all less than $1 million, so it would have been included in this. Projects under $1 million closings in the update. I think due to the materiality of the omission, we did not file an errata and thought it would be most efficient just to update on rebuttal, which again, we have subsequently withdrawn that request in this proceeding. But given we were talking about less than $1 million in plan additions, which are going to have less than a couple $100,000 of a revenue requirement impact, I think we felt it was probably most efficient just to acknowledge the omission and then update on rebuttal.
Your Honor, can I just have a moment to look through my exhibits to make sure I didn't forget anything?
Certainly.
Okay. I'm good, Your Honor. I'd like to move the admission of AOBA's Exhibits 1, 2, 3, and 4 into evidence.
No objection, Your Honor.
With no objection, so moved. So entered.
It's complete. My
You've
question.
been, okay. All right, then next, I believe we would have MEA.
Yes, thank you. Hello again, Mr. Lemon.
Good afternoon.
I'm going to ask you some questions about the White Flint investment in part 2 of your rebuttal testimony. And I will refer you to Schedule 3 in part 2 of your rebuttal testimony, which is pre-marked by Pepco as Schedule RTL-2-R-3. And that schedule lists the plant additions for which Pepco is seeking recovery, correct?
This was to support what we were seeking under the forecasted test year proposal. What we're seeking recovery of under a traditional test year will be the plant balances that are in Company Witness Nelson's traditional test year revenue requirement. I just offer that because the forecast that we have for 25, the forecast that we have for 26, are no longer relevant for what we're seeking recovery of in this proceeding.
Okay, let me see if I can walk with you through your schedule and then see what's still there and what's not.
Okay.
And I'm referring to the April 24 version of that schedule. You didn't refile that on April 27, did you? The Schedule 3 of the rebuttal?
It hasn't changed between now and then.
Okay, great. So, do you agree that page 1 of that schedule relates to 2024 amounts, page 2 relates to 2025 projected amounts, and page 3 lists 2026 projected amounts?
Yes, that's correct.
Okay. And do you agree that the ITNs 74120, 74121, 74118, 72002, and
Can you say that last one again?
72002 and 72200 are all associated with the White Flint investment. And to help you check, I can if you need me to, if you don't know offhand.
Sorry, I was just checking because I don't know all the numbers of the ITNs off
So let's
here.
start with page 1 of that schedule. The first 2 items there, 74120 both and 74121, that's the White Flint, both safe White Flint.
Yes, those.
And
those
the
two.
first one is about 113.9 estimated amount, and the second one is 45.1 million.
Yes.
And then on the 2025 schedule, page 2, the first 2 items are also related to White Flint, 72002, 74121, those first 2 items, in 2025, schedule 2, page 2. I mean, schedule 3, page 2.
I'm just pausing. 72002 says it's Sligo to Linden. So just not knowing all the operational ins and outs of the project, I might just need to Company Witness Allo to confirm that's part of the White Flint bundle
Sure.
projects.
And then just going a couple of rows down on that same page 2, 74118, White Flint area. You see that one?
Yep.
And then a little further down, I can't count the rows, but there's the Linden substation 72200. Do you need Mr. Allo to confirm that is also associated with White Flint, or do you know offhand?
I don't know offhand, so it'd be helpful if you could confirm that that's part of that.
Okay, sure. And was any change made to that schedule at all relating to the White Flint ITNs based on adjustments Pepco made to remove the fully forecasted test year?
No, this schedule was in support of the fully forecasted test year. It's got all of the kind of projected amounts that supported that. We withdrew our consideration of this, so are no longer asking for recovery of the revenue requirements associated with these schedules. But given all of the interplay of parties' testimonies kind of referring to different schedules throughout the record, thought it would be cleanest just to leave it in for the sake of completeness of the record.
So what do you know offhand in total what you are seeking in this rate case for White Flint investment?
I don't know. It would be the balance that is included in Company Witness Nelson's cost of service as of September 30th, 2025. I think during discovery, there was a question asked for all the closings that supported our plant balance of that time. So I think he's got that in his information and supported that through discovery with those requests for the amount.
So if we were just tracking what was in your schedule, what is still relevant? Is page 2 not relevant? Is page 3 not relevant?
I'd say 2 and 3 are no longer relevant because they are forecasted information, and we're not asking for a forecasted test year revenue requirement at this point.
So if only page 1, I'm sorry, if page 1 of Schedule 3 is the only relevant schedule for which costs are being sought, based on the revenue requirements you say are in Mr. Nelson's testimony, but for purposes of understanding, what you've put forth in this case, you're still seeking those two 2024 amounts on the first 2 rows of page 1.
Correct.
And nothing else on page 2, nothing else on page 3.
Nothing else that's in my schedules here.
But is Pepco generally asking for anything for 2025 and 2026 in Mr. Nelson's testimony that we'll need to track with what you have here, or no?
Anything that he would have provided to parties through his testimony. Like I said, he's got our plant and service balance as of September 30th, 2025. So if there was any plant closings that occurred in that period from an actuals perspective, those would be embedded in his numbers. And if I recall, I think parties were recommending adjustments to his rate-based numbers that were kind of based on that information, but I don't know what those numbers were off the top of my head.
Okay, but just for ease and reference, for purposes of what the company is seeking, page 2 and 3 of your schedules are no longer relevant.
Correct.
Okay. And so you would want to refer to Mr. Nelson, or do you know in the approximate total of the White Flint investment costs for which you're seeking?
I would ask him just out of abundance
Okay.
of caution to cite the number that's in his revenue requirement. I have all the details for what was in my numbers, but with the recent withdrawal, these are no longer under consideration.
Okay, thank you. I have no further questions.
All right, let's go then to People's Counsel.
Thank you, Your Honor. Good afternoon, Mr. Lemming.
Good afternoon.
Let me get situated here. So, Mr. Lemming, I'd like to just a couple of the cross examinations you've had that have prompted a level setting question that I'd like to ask. So, when does the company determine that a capital investment has closed to plant, so to speak? Like, is that an accounting determination? Is that based on the operational characteristic, like whether a substation's been energized or not? How does the company make that decision, and when does it happen?
I'd say it's really both of those things, right? It's from an operational perspective, once that asset becomes used and useful in providing service to customers, so typically upon energization, we would say it's been placed into service, and at that point, from an accounting perspective, we move it out of construction work in progress into FERC Account 101 for gross plant and service. So it's kind of driven by the operations of the project being energized, being used by customers, and then from an accounting perspective, we'll see it move into the FERC accounts that we include for recovery in the rate case.
Okay, so just to be clear, so for the White Flint substation, the date electricity started flowing through the substation and being used to serve customers, that's the date that from an accounting perspective, the project was considered close to plant.
Yes, I mean, I think there's been different phases of when different feeders and things have cut over, but generally, yes.
Okay, thank you. Now on a slightly unrelated topic, rate case expense. I also have a clarifying question. So I took it from your back and forth with Ms. Francis that it's the company's position that the company's position is for full recovery of rate case expense incurred in this proceeding. Is that correct?
That is correct.
So that would also include recovery of costs related to Dr. Tulidar's testimony, which has been pulled in its entirety, both the direct and the rebuttal testimony.
That's correct.
Okay, thank you. So now I'd like to ask a few questions about the company's exogenous cost regulatory asset proposal. You discussed this at starting at page 3 of your direct testimony. Is that right?
Very good.
Yes, that's correct.
Okay. And so what does the company mean by exogenous costs?
Mr. Chair, if I could just get clarity, I thought that was struck in the rebuttal, which I actually was going to ask about that. It's not. So it's still in play. That's fine.
Yeah, I think if I could offer clarity if that helps, I think we took my rebuttal testimony out because company witness Nelson has identical rebuttal testimony, but the proposal has stayed in my direct.
Okay. So if you'd like me to repeat my question, Mr. Lemming, my question is what does the company mean by exogenous costs?
Certainly, I think we have a description of it on lines 12 through 15 of my testimony where we refer to these as costs that are externally driven, largely outside of our control, and volatile and unpredictable in nature.
And with the company's proposal here, Pepco would be seeking to the ability to defer recovery for minor storm expense, for pension expense, and expenses related to legislative, regulatory, or accounting changes. Is that right?
Yes, I'd say defer recovery or refunds to customers if the amount that actually occurs in a given period varies from what's included in rates over that time for those cost categories.
And this proposal is not specific to any costs incurred in this proceeding, I guess reflected in the historic test year filing that Mr. Nelson supports.
No, we're asking for this on a prospective basis.
Okay, thank you. And so, in the way that this proposal works, I think you describe it at page 8 of your direct testimony. Page 8, line 3. The way this works mechanically is the company would make a filing within 90 days identifying the event that impacts the cost of service, and then upon the commission's approval, the cost would be placed into a deferral account and then reviewed for prudency in the company's subsequent base rate case. Does that sound right?
That's correct for costs that fall into the legislative, regulatory, and policy kind of requirement bucket. For the costs that are storms and pension related, those will continually occur every month over time, and we would just track those into that deferred account to seek recovery of and a prudency review of in a subsequent rate case as well. Just noting we wouldn't, every time there's a storm, we wouldn't come in for an accounting order on that. That's more for the new legislative, regulatory, and policy requirements that might come up.
And so until the next, once these costs are incurred and placed into the regulatory asset under this proposal, would the cost in that regulatory asset be reflected in the utilities rate base for accounting purposes?
Regulatory asset or regulatory liability would be in, we would request it in a base rate proceeding to be included in rate base if it was going to be recovered over multiple years.
And would the company be earning a return on what's in the regulatory asset or liability?
Either earning or accruing for the benefit of customers that return if it was in rate base.
Okay. And so I'd like to focus on this, the proposed inclusion of new legislative, regulatory, and or other policy requirements. And under Pepco's proposal, changes in legislative, regulatory, or policy requirements that have an impact on the company's cost of service and emerge after a rate case would be eligible for inclusion in this regulatory asset. Is that right?
Pending a commission accounting order that it would agree that they're eligible for regulatory asset or liability deferral.
And are you familiar with the 9618 MRP lessons learned proceeding and the comments that Pepco filed with its sister utility, Delmarva?
Yes, familiar with those.
Okay. And so I have an excerpt of there that was in the packet that I passed out. Hopefully it's not lost in the fray.
I try to keep track of it. These 3 pages, I think you
Yeah.
exerted 9 and 10.
Yeah, the first page is the cover page. And I'd like to mark this as OPC exhibit. What are we at? There it is. Okay. OPC exhibit 7.
So marked. Which one is this? What's on the describe the document again. I just want to make sure I have everything straight here.
Yes, Your Honor, the document is the cover page. It says reply comments of Potomac Electric Power Company and Delmarva Power and Light Company, and the case, the docket numbers in the caption are 9618 and 9645.
Okay, got it. Okay, got it.
What was the exhibit number, counsel? I'm sorry.
Exhibit 7.
7, thank you.
Now, if you could turn to page 10, I think it's the third page in this. So take a look at the second full sentence from the top, at the top of the page. It begins with, to ensure more gradual rate changes. Could you please read the next few sentences out loud, and I'll let you know when to stop.
To ensure more gradual rate changes, the Commission should approve the use of regulatory assets and MYPs to recover the cost of exogenous events not yet included in MYP base rates, such as storm restoration costs, incremental costs to connect new customers, costs resulting from new legislative or regulatory mandates, including changes in tax law, unforeseen changes in pension and other post-employment benefits, and any other costs deemed appropriate by the Commission. The company has proposed that the Commission allow a utility to file within 90 days of such an exogenous event occurring outside of an annual informational filing, which would be more efficient.
Well, thank you. That's perfect. This sounds somewhat identical to the proposal the company's put forth in this proceeding. Is that right?
Yes, I do think it's similar in nature. It's kind of informed by our experience we've had through this process over the past few years.
So what are the differences between this proposal and what you proposed in 9618?
I think what we have proposed here, we did not specifically request new customer connections to be included in this proposal. Outside of that, I think it largely tracks.
So for purposes of the inclusion of new legislative, regulatory, or other policy requirements, that's identical to what the company proposed in the lessons learned proceeding?
I mean, I think we might have worded it a little differently here, that in our request here, we've referred to policy requirements and MYP. I think we talked about changes in tax law. I'd say a change in tax law is an example of a policy item, so I think we're probably a little different in our wording in our proposal here in this instant proceeding.
But functionally and effectively, the proposals are roughly identical.
Yes,
Thank you.
close to that.
Now, are you familiar with BGE's comments in the lessons learned proceeding?
Generally familiar with their positions.
So I'd like to ask you about, I have an excerpt from their comments also filed. These are the reply comments of Baltimore Gas and Electric Company. Your Honor, I'd like to mark this as OPC Exhibit 8.
So marked.
And Mr. Lemming, if you could turn to page 28. It's the second page of the document. And again, you don't need to read it aloud, but review starting at the second full sentence, all the way to the sentence that begins with any cost.
Yep, I've read that.
And this is identical or very similar to the language that was in Pepco's comments, correct?
Yes, I'd say very near identical.
Now, I'd like to ask you about an exchange that occurred at the legislative style hearing in case 9618. And I have an excerpt of that in the packet. And, Your Honor, I'd like to mark this excerpt as OPC Exhibit 9.
So marked.
Now, this excerpt here, and I have a full copy if the council wants to inspect. The excerpted portion is an exchange between BG Representative John Frayne, BG Representative Mark Case, and Commissioner Suchman with respect to the exogenous cost regulatory asset proposal. And if you could turn to the page marked 61, at the very bottom there, and review lines 16 through 21.
Your Honor, I'm going to just object just to the extent that I don't believe a proper foundation has been laid.
Explain that. I mean,
Well, this is a transcript of, I don't see witness Lemming's name here. I don't see him being a sponsor of this. So I don't know if the witness, recognizes this. So I just don't think the council's laid the proper foundation.
Well, I'm happy to do so, Counselor. Mr. Lemming, if you could turn to page 3, line 21. Or, excuse me, line 20. Is that your name?
Yes, although I don't know why it says Esquire after it, but other than that, that is my name.
I guess you got another.
I did stay at a Holiday Inn Express that week.
You were granted another degree in that proceeding.
I overruled then, and I don't have a law degree either, and they're calling me Your Honor, so there you go.
I keep telling people it doesn't take much to be a lawyer. It really doesn't.
Less to be an accountant.
Okay. So if the objection has been overruled, I will continue with my cross.
Sorry, you were referring me to 61, I believe.
Yes, page 61, starting at line 16 through 21.
Okay.
Sorry, that was a mistake. Line 7 through 16 on page 61.
Seven through 15, you said, or 16?
7 through 16, yes.
Yep.
So let me know when you're ready.
I've reviewed that.
So just from this exchange that you've read here, would you agree that there's discussion of exogenous events that would be taken out and put into a regulatory asset?
That's the discussion. There's a reference to something being 40% that I don't recall, as I sit here today, removed from this proceeding, what that was in reference to, but in general, it's talking about costs that would move into the regulatory asset.
And in particular, exogenous costs?
Yes, exogenous costs, correct.
So now if you could turn to page 64 and review lines, starting at line 15 through 21.
All right, I've reviewed that.
And here, you'd agree that Commissioner Suchman is providing an example that the Climate Solutions Now Act is a legislative or regulatory mandate, and that everything the PSC is doing is sort of based on that. Does that sound right?
Yes, that is correct in terms of what Commissioner Suchman is articulating here.
Now turn to page 65 and review lines 3 through 7.
Yes, I've reviewed that.
And here, is it correct that Commissioner Suchman describes the inclusion of legislative or regulatory mandates as an exception that could swallow up the rule and could invoke us in a lot of litigation that distracts from what the PSC is trying to do, which is to regulate and keep costs down? Is that right?
Yes, that's correct. That the cost category of regulatory and legislative requirements are discussed in that manner here.
So does Pepco's exogenous cost proposal for new legislative, regulatory, and accounting changes in this proceeding include any guiding principles on how the company would determine whether a new legislative, regulatory, or other policy requirement impacts a change in the company's cost of service?
Any guiding principles? I don't know that we specifically outline guiding principles, but we would look to where new policies have been enacted by the legislature or new dockets might have been opened by the commission that result in incremental costs or incremental savings to customers, and make a filing to note that we would request those to be considered for this exogenous cost treatment.
And you'd agree that there are numerous commission orders issued each year. There's new legislation passed each year, and all of that could impact or change the company's cost of service. Is that right?
Yes, I think that's correct.
So under this proposal, would costs related to any or all of those regulatory or legislative changes be eligible for inclusion in the regulatory asset?
I'd say potentially if it's not specified through the regulation or legislation what the recovery vehicle is, that we would potentially request through this vehicle.
And would the company be able to earn a return on those costs until they are reviewed for prudency in the next rate case?
No, it would not.
Would not, but they'd be reflected in the regulatory asset. That's correct.
Yes, it would be held in a deferred account until the time that the commission could review them and authorize inclusion in rate base at that time.
Okay, so at some point, if the commission approves it, all the costs for all these changes in response to new legislation, new commission orders, new regulations, all of those would be eligible for inclusion in rate base at some point, subject to a prudency review.
If allowed by the commission.
Okay. And is it correct that your testimony does not reference any of the concerns Commissioner Suchman expressed in the 9618 proceeding?
No, it does not.
Is it correct that this proposal would afford regulatory asset treatment to any policy-driven costs that arise from ordinary commission orders?
It would allow the opportunity for us to request that treatment from the commission for a regulatory asset or a regulatory liability.
And is there any form of limitation built into the company's decision-making process for determining what's eligible for inclusion in the regulatory asset?
I'm sorry, can you repeat that question one more time?
So I take it from your testimony that the scope of potential impacts to legislative and regulatory changes is pretty wide. So my question is whether in the company's proposal, in your testimony, if there's any discussion or explanation for whether there's any limitation to what the company could consider.
I don't think we specifically called out any limitations. I mean, I think we're talking about the kind of things that we're often talking about in these proceedings with respect to new programs and new requirements that are placed in our utilities that we'd be looking at. I wouldn't say we're looking at every single conceivable change that might come out of a legislative requirement. It's really, I think, the new programs and requirements to execute new things that we'd be looking at in this cost category. And I think the limitations are, what the commission would ultimately deem reasonable to request. I think we would evaluate that when making those requests to the commission.
Okay. So now I would like to change topics here and ask you a few questions about the company's adjustment for net operating loss carryforwards.
Certainly.
It's a bit of a radical change and a less interesting topic.
Our tax department would take offense, but I'll leave it at that.
I mean, it can be interesting when you get into the weeds. So at part 2 of your direct testimony, starting at page 8, you discuss an issue regarding a rate-making adjustment related to these net operating loss carryovers. Is that right?
Yes, I don't think it's specifically a rate-making adjustment, but a change in our rate-making treatment for how costs are reflected in this proceeding.
And now this issue relates to the normalization of the tax benefits related to accelerated depreciation, and accelerated depreciation is what gives utilities a tax benefit for capital investment. Is that right at a pretty high level?
Yes, that is correct.
And utilities that claim accelerated depreciation receive the tax savings from that immediately on the condition that the savings are held in reserve and returned to customers over the entire lifespan of that asset. Is that right?
That is correct.
So you'd agree that accelerated depreciation is one tool by which the federal government incentivizes utilities to reinvest in their distribution systems?
Yes, I believe that's a tool.
Okay. And normalization is the term for remediating potential intergenerational equity issues that arise by requiring the benefits of accelerated depreciation to be returned to customers over the entire asset's lifespan. Is that right?
Generally, I'd say that's fair.
And this is the normalization rule, the requirement that affect the adjustment for the kind of timing of when the tax benefits are dispensed and when the company can realize them. That's the normalization rule.
Yes.
Generally. Okay. So now that we're all squared on at a very high level of normalization, I'd like you to help walk me through how the normalization rules and net operating loss carryforwards interact. So at a very high level, if you can answer this, what's the tax net operating loss?
Tax net operating loss is when on a company's financial statements that it reports to the IRS, if once you take into effect things like accelerated depreciation that you can claim as a deduction to the income that you earned in a given reporting year, if you are at a loss, we call that a tax net operating loss at that point.
And corporate taxpayers have the opportunity to carry back or carry forward these tax net operating losses to reduce their taxable income in prior years or in future years. Is that right?
Yes, that's correct.
Now, how does that work if the taxpayer, in this case Pepco, is an affiliate or of a parent company such as Exelon? And Exelon, my understanding is that they file a single consolidated tax return every year.
Yes, and you just touched on why I was pausing for a moment as I was explaining them. So Exelon files one tax return for the Exelon Corporation with the IRS, and so that will reflect Exelon's consolidating taxable income or taxable loss to the IRS in a given year, which reflects, the buildup of, Pepco, DPL, ACE, PECO, BGE, all of our income up to the parent company. And they'll file one consolidated return. So, just that if Exelon's consolidated books reflect in a taxable loss that it can use for a given year as a result of Pepco's contribution to that, it'll be reflected in what Exelon reports up to the IRS for a given year.
And so, if Pepco incurs a tax loss in a given year, Exelon would be able to use that tax loss to offset the tax liability of another Exelon subsidiary. Is that right?
Correct.
And when a Pepco tax loss is used to offset the tax liability of another affiliate, Pepco would receive a cash reimbursement for the use of the tax loss. Is that roughly correct?
That is how we had been treating these types of interactions until these private letter rulings were issued by the IRS to another taxpayer, yes.
So we'll get to the private letter rulings. Just to be clear, so under the old way that Exelon and Pepco did it, upon receipt of the reimbursement related to the tax loss that Exelon was using, the tax asset that's related to the net operating loss would effectively no longer be recorded on Pepco's books. Is that right?
Yes, that is correct. We tried to as efficiently monetize those as we could for the benefit of our ratepayers to take advantage of that interest-free source of capital.
And as you alluded to it, Pepco, this practice recently changed in response to some IRS private letter rulings?
Yes, June of 2024, that's correct.
And so could you give like a very high level explanation of like what the change that Pepco made is?
Certainly, it's discussed here in my testimony, but effectively what we saw was in June of 2024, there was another entity that treated their consolidated taxes in a similar manner that we're talking about for Pepco, where if we were able to have another affiliate of ours take advantage of those tax losses that we had on our books, they would pay it for us, help us reduce our tax assets on our books to get the cash in. There was another entity that had that same fact pattern that received a private letter ruling from the IRS that said for rate-making purposes only that was not the appropriate treatment of those tax loss carry-forwards, and that they needed to reflect their rate-making books on a standalone basis without consideration for how you could monetize these tax assets between affiliates based on each affiliate's tax operating position in a given year. And so they basically said if Pepco can't utilize that tax asset in a given year, sorry, they didn't say it to Pepco, they said it to this other entity. If you can't utilize that tax asset in a given year, keep it on your books as an asset until the time such that that individual utility on a standalone basis can utilize that tax asset.
And so does that impact how Exelon gets to take the tax, the net operating losses recorded by Pepco and use it to offset its own tax liability?
No, it does not change Exelon's tax reporting or operations in any way. This is a determination the IRS made for rate-making purposes specifically.
Okay. So just to be clear, so Pepco still gets the cash reimbursement from from its parent company, or from the affiliate that is claiming the net operating loss, but the difference is that the tax asset associated with the net operating loss remains on Pepco's books for rate-making purposes.
Yes, I mean, we still maintain all of our intercompany transactions in terms of cash flows in accordance with how we did before. We are now just looking at the IRS guidance in terms of how they, they have directed that they would review these types of transactions on a standalone utility basis.
Okay, and so this change in accounting practice, kind of effectively, this change, it reduces the balance of accumulated deferred income tax, and it decreases the amount of estimated deferred income tax. Is that right? Like, what's the rate-making effect of this? Like, how is it? How does the accounting work for purposes of determining a revenue requirement?
Yep, I think you just read off, or I don't know if you read off, but referred to what I have on page 12 of my testimony in terms of the adjustments we have made. In terms of the rate-making implications of this are reductions to our accumulated deferred income tax and our income tax regulatory liability, what you referred to before as the means by which we spread these amounts kind of over the life of the asset. Those will both be reduced, which result in an increase to rate base.
Okay, and do you recall what the increase in rate base for the traditional test year compliance filing is?
I have in my testimony what was in the forecasted test year. I don't know the traditional test year off the top of my head. I would expect it to be generally ballpark, but they will vary due to the time differences between them.
Yeah, just without getting into a specific number, I can ask Mr. Nelson the specifics. But just would you agree that it's a fairly sizable adjustment to the company's rate base?
I'd say it's about a $40 to $45 million impact to rate base, and overall about $5 million or so from a revenue requirement perspective. It'll vary, a little bit based on the period in which you're looking at for those costs.
Okay. And you referenced the IRS private letter rulings. To your knowledge, are those rulings binding on every taxpayer?
No, they can only be relied on for the taxpayer they were issued to, but we view them as instructive in terms of how the IRS would interpret, tax interpretations for other taxpayers with the same types of circumstances before them.
Okay, thank you. Just a couple more questions, Your Honor. So, Mr. Lemming, I have two DRs that I'd like to ask you about. There's OPC DR 3-3 and OPC DR 17-3. And each of these DRs provides an itemized list of expenses incurred and charged to FERC account 426.1. Your Honor, I'd like to mark DR 3-3 as OPC Exhibit 10 and DR 17-3 is OPC Exhibit 11.
So marked. Which one is 10 again?
Exhibit 10 will be OPC DR 3, number 3.
Number 3. Okay, thank you.
And Mr. Lemming, you sponsored the response to this DR, correct?
Yes, I did.
And to your knowledge, is the information contained in these DR responses accurate and true?
Yes, it is, to the best of my knowledge.
All right. Thank you. I have no further questions, and I'd like to offer the Exhibits 7, 8, 9, 10, and 11 into evidence.
Your Honor, the company does not have an objection to OPCs 7, 8, and 9. I would just note that those are just portions, and I would just simply ask the chair, ask the chair to take judicial notice of the complete document so that they can be used in briefing. And for OPC Exhibit 10, the company objected to this. We provided a response just for purposes of discovery, but I believe that the objection was relevant because these are donations for which we're not seeking recovery.
This is data request 3?
3-3, yes, that's correct, Your Honor.
And 17-3.
Pardon me?
And 17-3, Your Honor.
Oh,
Yeah.
okay.
And if I could respond to the company's
please do.
objection. So it's come to our attention that participants in the public comment hearings on April 14th and April 17th represent organizations that Pepco has donated to in 2024 and 2025. And for purposes of completing the record, we'd like to put in evidence that allows us to identify the specific amounts that Pepco has donated to those organizations.
And is that in, which one is that in?
That's in both.
Both?
Yeah, OPC DR 3-3 is the donations for 2024, and OPC DR 17-3 are the donations for 2025.
Let's first move into evidence everything that we agree on. So that would be everything but for which ones? 10 and 11? Yeah.
That'd be correct, Your Honor. Yes.
Okay, let's move into evidence, all of them except 10 and 11.
And just to confirm, Your Honor, you are taking judicial notice of OPC exhibits
Yes.
7, 8. Okay, thank you.
Yes. Okay, back to 10 and 11. Sorry, this always happens at these rate hearings. Excuse me. Oh, there it is. All right, got it. Okay, well, on 10, tell me again, Mr. Seegers, why you were...
Well, I believe this would apply to both 10 and 11, but these are charitable contributions for which the company is not seeking recovery, so we don't see the relevance to this proceeding for these.
And if I could respond, Your Honor, the relevance here is it shows potential bias and a conflict of interest for the participants in the public comment hearing that spoke in favor of Pepco's projects last week.
So I guess the concern I have is can we directly connect the people who testified at the hearing to the list? And can we verify that those people are connected to that particular charity? I'm so it's not, so I'm actually not even dealing with the substance of it. I'm not sure that we can infer that somebody who says that they are from a particular charitable organization actually speaks on behalf of them, unless we were to, or somebody were to ask that question, but we didn't. So I don't know that we can actually make that inference. I'm a little concerned about making that inference without having better clarity on whether they actually, I mean, you know, anybody can testify and say that they speak on behalf of an organization, but we didn't ask them to verify that they actually speak on behalf of a particular organization.
There were also advocacy organizations that had a lot of people.
Had a lot of people, and so we'd have to parse through whether they actually spoke on behalf of. I think we're going down a slippery slope if we don't have better clarity. I mean, if somebody were to submit a letter and represent that they are speaking on behalf of an organization, I would have less concern about that aspect, and then would deal with the substance.
And I also think that, you know, we can take into consideration the opinions that were offered at public hearings, you know, from the various organizations, the ones who were in support of Pepco's rate increase and various reasons why, and the organizations that were opposed to it and the reasons why. So I think we can accord the proper weight to those comments without necessarily dealing with, you know, a direct list of participants. And as Commissioner Suchman said, I think I'm a little concerned about trying to make this linkage between donations and testimony.
Commissioner Linton, I think, also had a question.
Yeah, just a quick one. I guess my question for people's counsel is, are you suggesting that these advocacy organizations provided their testimony just because the company donated to them?
Not necessarily.
Sure. What would be the connection then? I don't.
So, not to preview a forthcoming cross-examination, but you know, for the instance, OPC, we asked discovery of 3 individuals that spoke at the public comment hearing on Tuesday. These 3 individuals specifically expressed support for cost recovery of the White Flint substation. We asked Pepco for communications related to those individuals, and whether they had communicated, because as a, you know, working for OPC, I know what's happening with substations, but, you know, as a regular customer, I couldn't spot one substation from the other. So that was a little interesting to us. And we got confirmation that Pepco had email correspondence soliciting these individuals to file supportive letters. And I'm able, you know, we can connect the organizations of those individuals to organizations that Pepco has donated to. So I fully, you know, OPC, it's not our position that individuals in the business community, individuals that do business with Pepco, shouldn't participate in the public comment hearings. That's not our position at all. It's for the whole public. But our position is that there should be transparency into the financial interests of those that are testifying on behalf in support of Pepco's rate case. And the transparency for that would be the donations that Pepco has made to those organizations.
Yeah, look, the sense I get from the commission is to not introduce them into evidence. So that's our ruling. Any further issues? If not, we'll proceed to Montgomery County if they're here. I don't.
They left, Mr. Chairman.
Okay. Staff.
Mr. Chairman, I have a lot. Do you, and I'm dying to do it.
By a lot, do you mean like?
Probably an hour. I can talk, well, I always talk fast. That'll help, right?
No, you know
No,
what?
no.
I said we'd, no, go ahead, Ben. Okay, well, I think I said at the very beginning of the day, I'd try to arrange this so that we would end somewhere between 4:30 and 5, and we seem to be at 4:32 right now. So why don't we pick this up tomorrow at 10 in the morning? What do
Thank
I
you.
have to procedurally do for that?
Yeah, when witnesses are being cross-examined and we stop, either it's for lunch or a break or for the
Right.
day, a witness can't talk to their counsel about what they're testifying to. So,
Okay,
so whatever Mr. Lemming has talked about in relation to part 2, he can't talk to Miss Curry and Mr. Seegers.
got that?
Right, or any,
Or any-
or any
Yeah,
other
the
counsel.
lawyers that are representing the company.
Right.
So,
Yeah,
I'm not going home with anyone today.
I was going to say, I think only one elevator works in this building, so. All right, with that understanding, thank you for, I didn't know that. With that understanding, we will adjourn for today and adjourn or recess? What, does it matter? Okay. In Annapolis, it matters. Okay, so we will adjourn for today and pick this back up at 10 o'clock in the morning tomorrow.